We have a full courtroom, as everyone is aware, some interest in the case. So before we take appearances or begin the proceedings, I wanted to go over a couple of things with everyone. First of all, for the members of the media, we have a one-camera rule in this courthouse. You will abide by it, or you'll be ejected. That is the camera. That is the only thing. The camera and operating the camera. There are some witnesses who do not consent to their picture being taken. You will not take their picture. This is not a situation where you take their picture and when they'll publish it. It's a situation where you don't take their picture. This cameraman aware of particular witnesses who have objected to the court will order you not to take their picture.
I'm currently not aware of who is not on the
All right. Counsel, will you advise the cameraman directly? Now, and before those witnesses take a stand, but that is the witness, so that we don't have the picture taken. That prevents the inadvertent depiction of the witness if it is not taken at all. Okay? So the witnesses who do not want to have their picture taken are who?
Dr. Ryan, our first witness.
All right, the first witness, the camera does not go on to the witness, but anywhere else in the courtroom. Good. All right, very good. The other members of the media understand. That is the okay. That is the sole here. So using your phones to take pictures of other pictures taken. Good. That's fine. That's the camera. Okay.
Question about the sound, the audio from the witness. Yes. May I record the audio? The sound.
There any objection to the testimony being heard? Very good. That's court order, you understand.
I understand.
If you take the witness's picture, you'll be in contempt for the court order.
I have that.
All right, very good. All right, anything else before we take appearances? You go on the record and start proceeding. My announce. Okay. Do we have your appearances for the record, please?
Michelle Diamond for plaintiffs. Allison Slater for plaintiffs. Jesse Hill for plaintiffs.
Peter Nigel for plaintiffs.
Vivian Pajari for plaintiffs.
For the defendants.
Amanda Mayron for state defendants.
Very good. Okay, well, we're here today on the plaintiff's motion for a preliminary injunction. There's been great many filings. I believe the court has had an opportunity to read all of them. But if you are referring to something in the record, please tell us exactly what you're referring to. So we'll try to put our hands on it as you refer to. And before we get both parties are aware of the court ruling on the motion to limit the spot of the data. Is that right?
Yes, ma'am.
So any other motions outstanding or pending that both deal with begin the process of preliminary injunction? You're aware of any other outstanding motions for arguments? I understand there was some activity last night about a particular witness. The witness has been withdrawn, is that right? All right, very good. Well, it's a plaintiff's motion for a preliminary injunction, so we'll hear from the plaintiff first.
Good morning. Michelle. I think we may have some feedback. Oh, okay.
I think what's going on is someone on the group has their vote.
Keep working.
All right, very good. Go ahead.
Your Honor, the state cannot dispute that prior to the court's temporary restraining order, SB 23 caused serious and irreparable harm to women in Ohio. Because they were deprived of the fundamental right to abortion, which is protected under the Ohio Constitution, women and girls were deprived of life-changing medical care. They were forced to undergo substantial burdens in traveling out of state to attempt to get the care they needed. And some who felt they had no other options were left to contemplate suicide. Today, you'll hear more evidence about the impact and harms of SB 23 from 3 witnesses for plaintiffs. First, you'll hear from Dr. Sharon Leiner. Dr. Sharon Leiner will testify that SB 23 bans the majority of abortions in Ohio, given how early it applies. She'll testify that abortion is safe and is important. She'll testify that the exceptions to SB 23 are unclear and insufficient, and she'll testify about the harms from denying women access to abortion and forcing them to carry pregnancies against their will. Dr. Stephen Walston will then rebut the opinions of defendant experts, Drs. Bowles, Parker, and Sullivan. Dr. Russ Walston will testify to the fact that abortion is healthy. Abortion is safe. And again, the exceptions to SB 23 are vague and insufficient. Because he needs to treat patients in the afternoon, you'll actually hear from Dr. Walston this morning prior to the testimony from the state experts, but his testimony will be squarely designed to rebut the evidence offered, the opinions offered in their reports. And finally, we'll hear from Dr. Stephen Jockey, rebutting Dr. Sullivan's opinion regarding the application of medical ethics to abortion. At the end of today, you'll conclude, as you did on the TRO, that to allow SB 23 to go back into effect would be to allow devastating and irreparable harm to women in Ohio. I'm going to call our first witness, Dr. Sharon.
Raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help me God.
I do.
Please.
Morning, Dr. Leonard. Good morning. Could you please state your full name and application for the record?
I am Dr. Sharon Lyons, the medical director of Plain Care to the Southwest.
And if I refer to your employer as PP SWO or SWO, do you know what we're talking about?
Yes, I do.
What healthcare does PP SWO provide?
PBS will provide reproductive health care. This can include annual wellness exams for patients, cancer screenings such as pap smears and breast cancer screenings, contraception, STI screenings, as well as abortion care.
And what's your current position in PP SWO?
I currently serve as a medical director.
Do you hold any other titles at PP SWO?
Under that title, I also function as the medical director of surgery.
And before I ask about your responsibilities in those roles, could you tell us a little bit about your educational and professional background?
I obtained a Bachelor of Science at Michigan State University in medical technology. I stayed on at Michigan State University and got my medical license at the College of Human Medicine. I completed my residency training in family medicine.
And during your residency, what types of medical care did you learn about?
Family medicine, all aspects of general primary care, from care of infants, delivery of neonates, care of pregnant women, as well as adolescents, middle age, into elderly.
And did you seek out any other type of training during your residency?
Yes, I specifically sought out training to be able to.
And what did you do after residency?
I joined as a staff position at the Plain Care.
And about how long were you with the staff?
That was just a little over 18 years ago.
Are you licensed to practice medicine in the state of Ohio?
Yes, I can.
And are you a board certified physician?
Yes.
Are you a member of any professional medical organization?
I'm a member of the American Academy of Family Practice, as well as the Ohio Society of Medicine.
And what are your responsibilities as medical director and director of surgery as well?
In addition to providing direct patient care, I also help form the policies and procedures under to provide all care in the organization.
Do you supervise any other positions or staff?
Yes.
And what type of direct care do you provide to patients?
Primarily, I provide abortion care, but I also provide care in our family planning clinics. There are IUDs or that are advanced practice nurses.
And what type of abortion do you provide?
I provide both medication abortion and surgical abortion.
Up to what?
Surgical abortion is up to 21 weeks. Medication abortion is from 20 weeks.
Approximately how many abortions have you provided?
In my career, I've provided about.
Dr. Leonard, did you submit an expert report in this case?
Yes, I did.
If you look at the binder in front of you and turn to tab 1, which has been marked for identification as plaintiff's exhibit 1, is this your expert report? If you turn to tab 2, is that your CV? And is this an accurate summary of your educational and professional credentials?
Yes, it is.
Your Honor, parties have stipulated to the admissibility of exhibits for purposes of this hearing. So at this time, we move to admit plaintiffs exhibits 1 and 2 into the record. And at this time, plaintiffs tender Dr. Langer as an expert in the treatment and care of pregnant persons and provision of abortion. Dr. Langer, is abortion a common procedure?
Yes, it is.
Do you know approximately how many women will have abortions during their lifetime?
About 1 in 4 women have an abortion in their lifetime.
Do you know how many women have abortions in Ohio in their average year?
In the most recent report, just over 20,000 Ohio women had an abortion.
And is abortion a safe procedure?
Yes.
Dr. Langer, are you familiar with the National Academy study titled "The Safety and Quality of Abortion Care"?
Yes.
Could you turn to tab 19, which has been marked for identification as plaintiff's exhibit 19? Is this the National Academy study that you're familiar with?
Yes.
Your Honor, we move to admit plaintiff's exhibit 19 into the record. What does this study find is the mortality rate for abortion compared to parent pregnancy?
The rate of abortion compared to carrying through childbirth, 0.8 per 1,000. Abortions are almost 18.8.
And do you know what the mortality rates are in Ohio?
Ohio are reported as just over 14. And in fact, they've also shown that for Black women, it's 2.5 times that Ohio.
Thank you. And from the National Academy study, did they make a finding as to the rate differences between mortality from abortion and mortality for carrying child to term?
Yeah, mortality is approximately 12 to 13 times greater for child.
And how does abortion safety compare to that of other common medical procedures that could be performed on an outpatient basis?
You compare to procedures such as colonoscopies, hysteroscopies, or adult tonsillectomy, it's far safer.
So abortion, according to national academies, is safer than colonoscopies or tonsillectomies? And how common are serious complications from abortion?
They're uncommon.
Do you have a sense of their approximate rate?
Less than 1% of patients will experience a serious complication as a result of an abortion.
And when complications do arise, how are they typically treated?
For the average complication, they can often be cared for in the outpatient setting in our office.
And in the thousands of abortions you've provided, how typically do patients require transfer to a hospital?
In our experience, it would be less than 1 patient.
Dr. Langer, do you know how the physical complications from abortion compare to the physical complications from pregnancy?
Yes. On average, a patient will have no long-term effects from having had an abortion. However, patients who carry their pregnancy to term can experience many changes in their body and health throughout pregnancy, during delivery, and after.
And does pregnancy cause stress to the body?
Yes.
Could you describe it?
One of the most important things is to change to how the heart cells function to help circulate the greater volume of blood within the body, which can cause stress to the heart, particularly if there are any issues with their heart function. The lungs must work harder and in addition have less space to do so as pregnancy progresses. The kidneys must have to work harder as well as the body becomes in a state where the blood is more likely to form and pregnancy health.
And can pregnancy exacerbate any pre-existing conditions?
Yeah.
Could you name a few of those?
Yeah, so anyone who already has a diagnosis of high blood pressure or hypertension, diabetes, mental health, sometimes autoimmune disorder, may experience worsening of their conditions.
And can pregnancy cause any new health conditions?
Yeah.
What are some of those?
So patients can experience new onset high blood pressure in pregnancy, as well as new onset diabetes, which will also increase their risk of having diabetes after they deliver, as well as disorders such as preeclampsia, eclampsia.
And are there any complications that arise not from pregnancy, but during labor and delivery?
Absolutely. There's always a risk that a patient may experience hemorrhage or heavy bleeding through their delivery process or after, as well as potentially the need to deliver by C-section, which is a major abdominal operation and may result in issues with future pregnancy.
Dr. Leiner, can carrying a pregnancy to term and giving birth have any impacts on a patient's mental health?
Yes.
Could you give me examples?
So patients who have pre-existing mental health diagnoses may experience worsening of those through pregnancy, in addition to the patients who may suffer from postpartum depression, which in some cases may not adequately be diagnosed or treated in the time after delivery.
And for complications that occur during pregnancy, when do those typically occur?
Typically, we would see pregnancy-related issues starting around the 20th week of pregnancy or after, but again, some may present primarily due to
Dr. Leiner, are you familiar with the Turnaway study?
Yeah.
So if you turn to the last 6 tabs in your binder, and these are tabs 33 and then 37 to 41. Take a look at those, and if you could tell us, are these summary reports of the Turnaway study? Dr. Leiner, are you familiar with the Turnaway study? So if you turn to the last 6 tabs in your binder, and these are tabs 33 and then 37 to 41. Your Honor, plaintiffs moved to admit exhibits 33, 37, 38, 39, 40, and 41 into evidence.
Any objection?
No.
Just make sure, 33, 37, 38, 39, and 41 or 40.
40 and 41. So 33 and then 37 to 41.
Very good. So,
Dr. Leonard, what is the Turnaway study?
It was a long-term prospective study that involved 1,000 women, looking at comparing those that were able to obtain an abortion when they desired one versus those who were denied or turned away.
And how is the Turnaway study regarded in the community?
It's considered the gold standard for looking at these effects on patients. There have been over 50 articles such as here that have been produced and published in the top journals from the study.
Are you familiar with what the Turnaway study found with respect to the impact of being denied abortion on patients' mental health?
Yeah.
Could you describe those findings?
They found that patients who were unable to obtain a desired abortion experienced greater rates of anxiety and depression and poorer health in the future.
And did the Turnaway study make findings regarding the economic impact of being denied abortion?
Yes, being unable to obtain a person's educational goals, employment goals led to patients having lower socioeconomic situation, as well as being less able to provide for the children that many of them already have.
Did it make any findings with respect to the impact on victims of domestic violence of being denied abortion? Findings regarding the economic impact of being denied?
Higher associated with those victims, the person perpetrating their abuse when they have people to.
Dr. Leiner, are you familiar with Ohio Senate Bill 23?
Yeah.
And if I refer to it as SB 23, will you know what I'm talking about? Yeah. What is your understanding of this?
We makes it a crime to perform an abortion after cardiac activity has been checked.
And what is cardiac activity typically?
Anywhere from the upper part of the 5th week of pregnancy to the early part of 6th week.
And to clarify, what is cardiac activity?
So if you're looking at it at that stage of pregnancy, it is a flicker of the early cardiac cells that are starting to develop.
Is there a heart at 5 to 6 weeks?
No, there's not a form.
And at that stage, are we talking about a fetus or an embryo?
An embryo.
Dr. Leiner, do most women know that they're pregnant at 5 to 6 weeks?
There are many patients who don't know.
And do you know what percentage of women in Ohio received abortions after 6 weeks LMP prior to SB 23 taking effect?
It was great many of our patients, upwards of 99%. 14% until the impacts.
Does SB 23 contain any restrictions?
It does.
Have you reviewed them? Have you reviewed the Ohio Attorney General disclaimer on the exceptions? What are these?
There's an exception for the life of the woman, there's a serious threat to the life of the woman, and well as the serious threat to irreversible harm to a body.
And as someone who provides abortion, are these exceptions clear to you?
They're not.
What's on?
Serious threat of death, it requires a person to make an assessment, and sometimes very quickly, as to whether or not a patient meets that criteria in regards to the seriousness. How close do they have to get to actually dying from their clinical situation? And having to think about and hesitate could cause someone to delay.
And are there any specific exceptions with any specific conditions that are accepted from the statute?
In the second portion that we mentioned, there is listed some obstetrical infections such as preeclampsia, an inevitable abortion, premature rupture of membrane, as well as diabetes and multiple sclerosis.
And are those clear?
They are not. Most of those have a range of seriousness that could occur, and it would vary in what a person may judge to be qualified under the exemption.
How do the issues that you just described impact providers' ability to provide abortion care?
It creates a situation where you have to second guess how someone may interpret your medical judgment, partly due to the significant penalties that may come with being accused of violating the law, and this could cause delays in care or potentially someone waiting until a person is sicker to be able to have their abortion done.
During the time that SB 23 was in effect, did your surgical center provide any abortions under the exceptions to SB 23?
We saw one
In the approximately 2 months that SB 23 was in effect, PPSWO provided one abortion pursuant to the exceptions?
Yeah.
In your expert opinion, are exceptions for the life of the mother and exceptions for serious risk of substantial and irreversible bodily harm sufficient to make sure that women who need abortion care can access it?
Yeah.
Why not?
Again, there will always be a variation in what a person's judgment is, to whether a patient fits those criteria. There may be time involved to determine whether or not someone would fit that criteria, as the provider may feel in regards to concern for violating the law and being abused and having a felony conviction.
And are there any health risks that fall short of those exceptions that you think warrant care?
There are a variety of health risks that do not be judged to meet those exceptions, but can cause significant difficulty for patients.
Dr. Liner, did you also submit a factual affidavit in this case?
Yeah.
Could you turn to tab 3 in your binder? Would have been marked, I'm sorry. Tab 16, it should be what's marked as plaintiff's exhibit 16, the affidavit of Dr. Sharon Liner. Is this your affidavit?
Yes.
Is everything in here true and accurate?
Yes.
Your Honor, we move to admit plaintiff's exhibit 16 into evidence.
You are in position to this to the extent of knowledge.
Dr. Liner, did you speak with all of the patients you described in your affidavit directly?
I did not.
For those who didn't speak to directly, how did you learn the information in your affidavit?
We were informed by staff who've spoken with those patients on the phone or in person as to what they were experiencing and hearing from them.
And are you personally familiar with the operational and scheduling changes that the surgical center had to make once SB 23 took effect?
Yes.
And are you personally familiar with the impact SB 23 had on patients and on staff?
Yes.
Were you present at the surgical center in the days and weeks when SB 23 took effect?
I was.
Could you describe what that was like?
We had to gather a team to start making phone calls to the 3 weeks of patients that were already on the schedule to be seen. And through that time, we heard lots of tears and anguish about what patients were going to do. As we started to see patients again after that first week after We had patients come in who were hoping they might be able to have their abortion under the Ohio law. We found out that they did not. And we had staff and patients crying together about what they were going to do to get out of state. We had patients who didn't know what was going on, and we had to inform them when they came in.
Did the surgical center have to cancel any appointments?
Yes, we did. We had many patients who we knew already did not qualify, and we would call them to give them the option of having information for me to go out of state or to come in and get that information.
Do you know about how many appointments you had to cancel? And how do you know that PPSWO had to cancel around 600 appointments?
We can see how many patients are scheduled on each day of our schedule and know how many weeks we're scheduled.
And can you describe how patients responded when their appointments were canceled?
You know, again, they were tearful. Sometimes they would get desperate and try to figure out ways that they might have to take things into their own hands or even threaten to harm themselves.
Did you observe any of these reactions personally?
Those particular, well, the patients who were crying and upset.
So I'd like to talk about PPSWO's procedures when SB 23 took effect. I'm going to grab water. So what happened when women called the health center seeking appointments?
So we had to inform patients of the new restrictions. If they were estimated to possibly be beyond the state limit at that point, they were given the option to come in. They could confirm where they were in their pregnancy and be given information and resources, or we offered some of those resources if they prefer to manage their own way out of state. We're able to. And
what happened when patients came in for
the process involved after getting checked in, they have their ultrasound to help determine whether or not they would qualify for care.
And do you know what percentage of patients had cardiac activity on that first ultrasound?
About 60% of patients.
60% of patients.
60.
And what happened with those patients?
So again, they were given the option to stay and speak with a staff member who could help inform them of where they could go. They were given the option to leave if they wished.
For the patients who had no cardiac activity on the first ultrasound, were they able to obtain abortions that day?
Not on that day.
We're not.
In Ohio, you still have to complete the other legal requirements, one of which involves speaking face to face. Perform an abortion.
And so for those patients, did you schedule follow-up appointments?
Yes, most of those patients were scheduled just after that 24-hour consultation.
And what happened when patients came back for a second?
We did the ultrasound. That's whether there is any change in the status of no cardiac activity.
And were you present in the room when the second ultrasounds were performed?
Yes, when I was on service.
What percentage of patients had cardiac activity detected on the second ultrasound?
60% overnight have developed cardiac activity.
60% of women who came back for the appointment had cardiac activity detected overnight.
Yes.
And so what did you tell those patients?
We tell those patients that no longer. I told those patients they no longer had the option for an abortion in our clinic or in Ohio, and that they could wish to pursue an abortion out of state that would be with them.
And you mentioned some patients stayed in the clinic after they were told they had an abortion in Ohio. Did you observe any of these patients?
Yes, I did.
What did you observe?
Well, and initially when we informed patients, it was not uncommon to have patients break down crying. Sometimes if I was on duty elsewhere in the center, people would know whether or not it was cardiac activity, which would hear the wailing outside the ultrasound room. Patients would struggle to look at different locations in foreign cities and foreign states to them and try to figure out what the easiest way to get there was, to contact family members or friends to see if they could transport them, or to struggle to read a bus map to see if they could get out.
Did you observe these patients encounter any other obstacles in getting care out of state?
So many of our patients already have children and are the primary person responsible for those children. So trying to find someone who could care for them so they could travel out of state, in addition to the fact that they need to have time off work if their job allows them, and to also think about staying overnight in these places. they're far enough away, it would be difficult to go out and back.
Are you aware of patients who were able to obtain abortions in other states?
Yeah.
And can you describe the experience of those patients?
Again, it varies, so some patients would have their own transportation to those like locations, most of them would need to spend at least one night in that place, so they can get there, have their procedure, and then safely come home. Many patients, especially if they wanted to be sedated for part of their procedure, had to tell another person in their life what they needed and what their plan was. Even if they may not have wanted to involve other people in their.
Were patients typically able to access abortion promptly in other states?
No.
How long did they have to wait?
We were seeing delays of about 2 to 3 weeks for patients to get an appointment out of state.
And what are some of the impacts of having to wait 2 or 3 weeks to get an abortion?
In addition to having to wait longer for healthcare that you have decided upon that you need, we saw patients who were so sick with their pregnancy that we were having to try to prescribe anti-nausea medicine so they could safely drive to their out-of-state locations of their abortion. And of course, anyone who had difficulties with that pregnancy had to wait even longer to service.
Could some patients be pushed outside the window in which they could obtain abortion in other states, waiting 2 to 3 weeks?
So absolutely.
Leonard, I'd like to ask you about some of the patients that you met with directly. Could you turn to paragraph 14 of your affidavit?
We saw about a week after this law went into effect, she came into the office seeking an abortion, that she needed to terminate her pregnancy so that she could receive her cancer treatment, her recent cancer, and be around to help care for the child that she had.
So she already had one child?
She already had one child.
And what happened when she came in?
We did her ultrasound and we found that she was already 8 weeks pregnant and had cardiac activity as we expected.
You testified previously that SB 23 contains limited exceptions. Did you believe that this patient qualified for any exception?
We thought that she might be a person who would qualify for the exception of serious irreparable harm to a body.
And were you able to provide her with an abortion?
No, we were not.
Why not?
We followed what is our community standard for documenting the need for a medical exception to an abortion, which was to the treating provider and getting a letter stating that they met the criteria. And in this case, we were unable to obtain a letter from the provider to do so.
Dr. Leonard, what is a community standard?
It's a practice that everyone in the area who provides similar care abides by and follows.
And why is this the community standard?
Many of the laws that we have to follow have penalties that are very severe in regards to abortion provision. And it is felt to be protected to have an additional physician certify the patient meets the criteria of the exception in the law.
Do you have any reason to doubt that the state would challenge your view?
Yes, I think multiple interactions with the state makes me concerned that as an abortion provider, it might be questioned whether I was qualified or had the information needed to make such a decision, even though it is in the purview of my medical background.
So were you able to obtain a letter from her other health provider?
I was,
Do you know why?
my understanding is the provider was not comfortable providing such a letter.
Did they explain why?
I did not have a detailed explanation of why.
Turning back to your affidavit. Actually, before we move on, do you know what happened with this patient?
We don't know exactly what the outcome was for her.
So you don't know if she was able to get care in another state?
We don't know if she ended up somewhere else.
Turning back to your affidavit, could I direct you to paragraph 15? Do you recall this patient?
I do.
Was she your patient?
Yes, she was.
What happened with this patient?
This patient came in for a consultation of preoperative visit and informed us that she had been diagnosed just 2 days before the doctor's decision that she had some severe fetal anomalies that included not having any lower extremities in her pregnancy, as well as a defect in the abdominal cavity that allowed portions of the intestinal system and the heart to protrude from the abdomen.
So the fetus had portions of the abdomen and the heart protruding outside, and the fetus had no lower extremities.
No lower.
Dr. Lerner, what would life look like for a fetus delivered with these types of abnormalities?
Yeah, if a fetus like this survived, it was really limited capacity to life and potentially very difficult.
And were you able to confirm these abnormalities?
We have a record system that allows us to see outside records or ultrasound and indicate the patient.
And you did in this case?
Yes. we did.
Were you able to perform an abortion for this patient?
No,
Why not?
the SC23 does not contain any exception to in regards to fetal anomalies or abnormalities.
Is there any exception for fetal anomalies where the fetus will not survive? Can you describe how this patient reacted when you told her she would not be able to provide an abortion in Ohio?
She was very disappointed, but even further disappointed when she learned about the delays of getting into numbers of weeks, especially in the
Was this a desired pregnancy?
Yes, it was.
So do you know what happened to this patient?
We know this patient initially got scheduled out of state. We do not know what she followed through with that.
Dr. Leonard, based on your experience providing care under SB 23 when it was in effect, what are your views on how it will impact patient care if it's allowed to take effect again?
It will again severely limit the access for Ohio women to abortion. It will lead again to them traveling out of state. For many of our patients, possibly never being able to obtain an abortion. We already talked about all the risks that can come with being forced to carry the pregnancy and childbirth.
Dr. Leonard, we came to the courthouse together this morning. Did you do anything to prepare for our coming to the courthouse?
We had 2 sessions of preparation for the last 2 days.
Did you wear anything different from what you might normally wear?
Yeah, but
What were you wearing?
we heard that there might be some protest activity, so I went ahead and wore my alarm.
Dr. Leonard, why do you do this work? Why do you do what you do?
There have been several stages in my life where I decided how important it was to have access to abortion for women. And it started very early on. I grew up in a rural community that had limited access to sex education. Unfortunately, my parents were pretty open to talking about sex, so I felt pretty well prepared. But I suddenly realized at graduation, we had approximately 100 of us graduating, and 9 of my classmates already had children. And I decided I wanted to help do something about that. And so when I was in medical school, I joined something called Medical Students for Choice, and we were present together the day that Dr. Slotkin was shot. And my classmates around me had started talking about how they were scared now and they didn't want to provide abortion. And it really made me realize that if I didn't take that step, that patients may not have access, we may have to suffer all the consequences that we talked about today.
And Dr. Leonard, did you do anything differently at home because of that experience?
Yeah, I would say it's funny the things you get used to doing. But especially after that, we could go around and close all of our blinds every night so no one comes into our house. We appreciate not having pictures. We taught our children and we don't post any pictures online whatsoever. Every single address label off of this mail that comes to our house, and we do have to be aware if something comes to the house that you're not aware of. You know, someone may have something potentially dangerous to you.
And you mentioned your experience with your classmates and them being pregnant upon graduation. Why is it important to do this work? How does this change people's lives?
It can have a significant impact on people's lives. People can achieve their educational goals, their life goals. They can still have the things that they want and desire to do it at a time of their life that they're the best prepared to raise children.
Thank you, Dr. Leonard. No further questions.
Information.
Morning, Dr. Leonard. My name is Amanda. I'm in the deposition. We have to do a call. I'm very sorry that you had to experience that that part of it, I understand that would be very difficult. And I do sympathize with that. Just to be clear about your testimony, it was your testimony that abortions were safe for women, right? Yeah. And you testified that you perform abortions, thousands of abortions, isn't that right? So prior to June 24th of this year, you checked for fetal heartbeats before you performed abortions.
Yeah, we did every patient that we saw. We had
And you informed your patients whether you detected cardiac activity during that examination.
Yes, we did.
And you offered your patients the ability to see the heartbeat on ultrasound. Is that correct? And today, you check for a fetal heartbeat when the patient comes to your clinic for a consultation for an abortion.
Yes.
And in fact, you will check for fetal heartbeat prior to performing an abortion if you did not detect the heartbeat the first appointment. Is that right? Okay. Have you performed a post-viability abortion in your career? But you know that Ohio law allows for an abortion after viability in certain circumstances. And you know that those exceptions allow abortion if there's significant risk to life or the health of the woman.
I know of that. I'm not as familiar with those exceptions as I am with this.
And that would include such circumstances as rupture of membranes, significant bleeding, or prior illness substantially exacerbated by the pregnancy.
Again, I'm not as familiar with those, but that does sound like categories where.
Isn't it true that you know what the exceptions are that allow for an abortion after a heart is detected under the Heartbeat Act or Senate Bill 23 issue?
I know we're going to judge an exception.
And you did perform an abortion after cardiac activity was detected in a fetus for a patient while the Heartbeat Act was in effect.
Correct. For one patient.
And you performed that abortion under one of the exceptions provided by the law.
Yes.
Because that patient had significant cardiac disease.
Yes.
There wasn't an immediate risk for life, though.
She was stable enough to be seen in our outpatient center. But if she did continue the pregnancy, there was concern that she had significant issues or life-threatening issues.
You determined after consulting with her cardiologist that her life or health would be at serious risk if she continued the pregnancy without an abortion.
Yeah. The patient already knew this information before she came in. She knew they were already.
And you haven't been prosecuted for performing that abortion, correct?
It has been not all that long since we've done that, but there's been no action on that report.
And in fact, no one from the Ohio Department of Health or the medical board has contacted you about that abortion, have they?
Not at this time, but we were fully prepared for the potential of an inspection or question for pregnancy.
But again, you have not been contacted by the Ohio Department of Health or the medical board. Okay. You agree that an ectopic pregnancy can be treated under the Heartbeat Act or Senate Bill 23.
Yes, it is delineated that is not included in the law.
And you agree that a patient can receive an abortion after cardiac activity is detected in a fetus if the patient will suffer an inevitable abortion under the Heartbeat Act or Senate.
That is one of the listed.
And you agree that a patient can receive an abortion after cardiac activity is detected in a fetus if the patient suffers from preeclampsia under the Heartbeat Act.
Again, as mentioned, there are a lot of variations in the severity of preeclampsia. So it does cause one question, someone has mild preeclampsia that qualify versus a patient who has very severe. And where does that shift happen? And would that person be at risk for violence law if they didn't do that one?
But in the plain language of the law, is this condition, preeclampsia, within the exceptions provided by the Heartbeat Act?
It is.
And you agree that a patient can receive an abortion after cardiac activity is detected in a fetus if the patient experiences premature rupture of membranes under the Heartbeat Act or Senate Bill 23.
It is listed, but again, there are variations as far as a patient may be stable initially when rupture of membrane occurs. And when law is written with the seriousness that it is, a person could hesitate, particularly due to the potential penalty as to whether or not he needs to wait until the patient is more sick before doing the intervention.
But there is nothing in the language of the Heartbeat Act that qualifies when abortion can be performed with these conditions, is there?
It does not specify.
And your clinic isn't at risk of closure, correct?
Based on the exemptions, can you clarify, please?
Your clinic is not at risk for closure because of the Market Act, is it?
Not yet, not in this.
And you don't have firsthand knowledge of everything that was in the affidavit that was submitted as an exhibit to this court, correct?
Not
In your testimony, you tell the story of a woman that came to your clinic for consultation that was undergoing chemotherapy for her cancer, correct?
Yeah.
And you were the physician that met with that patient during her consultation,
Yes.
and you were able to confirm her condition both by consulting with her physician and by reviewing the electronic medical records, correct?
As well as talking.
And her provider did not continue treating her cancer if she remained pregnant.
Correct.
And it was your reasonable medical judgment that her condition might allow for her to obtain an abortion under an exception to the Heartbeat Act.
I felt she might be a patient. who qualified.
And because you could not obtain a letter from her provider, you refused to perform an abortion for that patient.
Because we didn't have the proper documentation, we could not qualify for some of the exemptions.
But nothing in the law requires you to obtain a letter from another doctor, does it?
That is correct, but we also don't want to deviate from our community standards and do something different than like this.
In fact, only the physician who performs the abortion is required to sign the form that must be submitted after an abortion is completed under one of the exceptions from the Heartbeat Act.
That is correct.
And so it's that physician's reasonable medical judgment that matters.
It does not mean that having supportive information from a patient's treating provider is not helpful or more defensible than what's questioned.
But that's not required by the law, is it? You didn't obtain a waiver of the doctor-patient privilege for this patient, did you?
There was not a need for a waiver to give a small amount of information that was not identified to tell the story of the effects of this law.
And you spoke about the patient in paragraph 15 of your affidavit with the fetal anomalies. Did you obtain a waiver from the doctor-patient privilege to share her information?
Again, a small amount of information would not call out or potentially identify this individual.
In fact, neither you nor any of your staff obtained a waiver of the doctor-patient privilege for any of the patients whose information is contained in your affidavit.
Counsel, I'm instructing you to cease any suggestion that a waiver was required. The Ohio Supreme Court spoke very clearly on this point in the Bill case. Identifying information, the waiver is not required as a matter of settled law. So, I think we demonstrate that it's not a question go ahead. But this merely suggests erroneously that a waiver was required, providing information that's set forth in the affidavit, or that everyone has testified to, but it's not.
Your Honor, we would respectfully disagree. Under Ohio law, statutory law, RC 2317.02b, a doctor is barred entirely from testifying at all about communications or information learned in the course of the doctor-patient's relationship in court and in affidavit. If it's barred, there is the only exception.
Counsel, you've been instructed. Go ahead. It's the law, this case, at this point, you can disagree on it. Go ahead.
Your Honor, would you like us to submit a,
I'd like you to get your question, follow the court's direction.
I think we have. Thank you.
You redirect. Sure.
No further questions, Your Honor.
The court has a couple of questions of its own. I feel on the with respect to exceptions that we will accomplish. You include information about a case involving fetal anomalies. You testified that there's no exception for fetal anomalies in the statute, is that right? What options does a woman have under this law as you understand it when they kind of fetal anonymous. I mean, they can still try to deny the exceptions if it presents a threat to their own health or safety, is that right?
If that were the case, that, he is common as an anomaly that affects the fetus. If there was something that affected internal health, and he could attempt to qualify.
All right, so in this case, the fetus will not survive. The right word is not.
I mean, it may survive delivery initially, but probably would not last very long.
So if the Ohio law was law everywhere, it was the option to travel. What would this particular patient situation be if there would have, there would be required to carry it there?
Will be required to hear that this return. And in fact, depending on how the very
Okay. With respect to anonymous status of any exception, when are most people anonymous affected in the course of pregnancy, or is that? Is there no way to say? I don't know. I don't know, is there a normal point at which they are normally affected or not?
There are some facts, well, in the first trimester, there was validation that they are increased risk. Some of those known, but generally many of them are providing until at least the 20 weeks pregnancy. We talked about the formation of the heart, we often go through those magnet scans and ultrasound until at least 20 weeks pregnancy, ideally be a little bit longer, because that when you have fully more heart and the organs to fast forward and develop.
Okay, so at least on the issue of fetal anomalies, there's a great burden placed on pregnant women, and a tremendous amount of risk of having to carry them out, and then deal with the death of other people immediately.
We talk about patients who have a lot of emotional distress and having to carry it, will not survive or will suffer.
All right, as someone who's active in this field, were you invited to testify before the General Assembly on SB 103?
No.
Do you know of anyone with your expertise or any abortion providers were not able to testify?
I don't recall, I was not involved directly with that stage.
Do you know if the issue of fetal anomalies was considered as one of the potential exceptions? Are there any other procedures other than abortion that you're aware of that carry potential criminal penalties if your medical judgment is second guessed after the fact? All right, and are there any procedures that men routinely have that carry potential criminal penalties? Okay, just want to make sure. All right, court doesn't go further. Many of the court's questions have raised questions during the council. They would like us not to go. I think. Very good. Thank you. Excuse me. Why don't you take that?
Thank you.
Next witness.
The plaintiffs will call Dr. Stephen Ralston. Dr. Ralston will be appearing by Zoom.
Okay. Now we're going to find out whether our technology actually works. If it were over, she's going to. Gotcha.
And Your Honor, would you like the screen to be facing more sideways so that you're able to see the witness?
I'm on the Zoom.
You have it.
Right here, so I can see.
Perfect.
If the witness is on.
I'm thinking on right now. Your Honor. There it is.
They consider that a loss.
Can you raise your right hand? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you make it so that Dr. Wilson feels extreme rather than the rest of it?
I think if you spotlight for everyone, that might.
Which one? I'm not sure how to do that.
He says it's working.
Your Honor, just briefly, we will be sharing a couple of exhibits, so if you have any trouble viewing them when they're shared on the screen, please just let me know.
Okay.
All right.
I'm having trouble hearing you.
Can you hear me now, Dr. Ralston?
Yes, I can now.
I'll try to speak into the microphone. All right, good morning, Dr. Ralston. Could you please introduce yourself to the court?
Well, I just changed my name and I spelled it incorrectly, so let me fix that. I am Dr. Stephen Ralston. Hello.
And Dr. Ralston, I'm going to ask you a couple of questions about your current occupation and your education background. We'll be submitting your CV to the court, so please feel free to give short and direct answers which will help the court reporter in this matter. Dr. Ralston, how are you currently employed?
I am a professor of OBGYN at the University of Maryland School of Medicine, and I am the medical director of the labor floor at the University of Maryland Medical Center in Baltimore, Maryland.
What are your duties and responsibilities at the University of Maryland?
I have clinical duties as a high-risk pregnancy specialist, taking care of pregnant women who come into the hospital to have babies for the most part. I have teaching responsibilities, which is managing the education of students, OBGYN residents, and maternal fetal medicine fellows on our labor floor and in the hospital. And I have administrative duties in managing the day-to-day activities on the labor floor, essentially ensuring that the care provided there is safe and evidence-based.
And do you provide any abortion care to patients as part of your duties and responsibilities?
I do.
And with respect to your teaching responsibilities at the University of Maryland Medical Center, do you teach the full range of obstetric care?
Yeah, I teach everything from how to talk to women who are considering pregnancy and preconception care to the management of pregnancy in the early parts of the first trimester, all the way through labor and delivery, and then complications that occur in the postpartum period. I teach about that as well.
And do you train medical students, fellows, and residents on abortion care?
Yes, I do.
And how long have you provided that training?
I'm sorry, I'm having a little trouble hearing you.
Apologies. For how long have you provided that training to medical students, residents, and fellows?
Well, I've been an OBGYN for over 30 years. I started providing abortions early on in my residency and then teaching abortion care to people below me in the hierarchy, probably since the early 90s. So I'd say close to 30 years.
And you mentioned your clinical responsibilities at the University of Maryland Medical Center. Approximately what percentage of your time is spent providing clinical care to patients?
I think if you looked at my contract, it would say 70% of my time is clinical. I think in actuality, it's more about 80 to 85% of my time is clinical.
And do you provide obstetric care to pregnant patients?
Yes.
In your career, approximately how many pregnant women have you provided obstetric care for?
Well, it really depends on what you define as obstetric care, but I have seen thousands of women who are pregnant in consultation, in assessment of fetal well-being through ultrasound, in managing their pregnancies in the outpatient setting, and in managing their pregnancies on the inpatient setting and on the labor floor.
And Dr. Ralston, do you deliver babies?
Yes, I do.
And you mentioned that you also provide abortion care to patients. In what settings have you provided abortion care to patients in your career?
In a variety of settings, both inpatient and outpatient. In my residency, Our first trimester abortion clinic was an outpatient clinic, but we also performed second trimester procedures in the hospital. When I moved to Boston after my residency, I performed abortions both in hospital that I was working at, as well as at abortion clinics that existed in Boston at the time. And then when I moved to Tufts for my maternal fetal medicine fellowship, I was primarily doing inpatient second trimester abortions, mostly for fetal abnormalities. And that's been the majority of the abortion care that I've provided since then, although I do occasionally work in outpatient settings still.
And you alluded to this, but before your current position at the University of Maryland, how were you employed?
Well, I'll just go forward chronologically. My first job out of residency was working at a community health center outside of Boston. I then joined the faculty at Tufts after my maternal fetal medicine fellowship, where I was for 15 years. I was the medical director of our prenatal diagnosis unit there. I was the director of the ethics and professionalism curriculum at Tufts while I was there. I then became division director of maternal fetal medicine at Beth Israel Hospital in Boston, which is one of the 3 major teaching hospitals in the Harvard system. From there, I moved to Pennsylvania Hospital in Philadelphia, where I was the chair of OBGYN and also a practicing maternal fetal medicine specialist. And then from there, I moved to Howard University in Washington, D.C., and then my current position at the University of Maryland.
Thank you, Dr. Robinson. Throughout your career, have you ever been a principal or co-principal investigator of a scientific study?
Yes, I've done a number of small clinical studies, mostly with medical students and residents and fellows around issues related to obstetrics primarily.
And have you authored or co-authored any peer-reviewed articles?
Yes, both in my clinical research as well as in my scholarship on biomedical ethics.
Approximately how many peer-reviewed articles have you published, Dr. Robinson?
Oh, it's on the order of 30 to 40.
What were these articles primarily about?
Almost exclusively having to do with pregnancy and complications of pregnancy, either the management of them clinically or ethical analysis of dilemmas that arise in clinical obstetrics.
And during your discussion of your history providing abortion care, I believe you touched on a few of these, but could you please tell the court generally about your educational background?
Sure. I went to public high school, and then I went to Yale University for my undergraduate degree. I then went to Columbia for medical school. And then I went back to Yale for my OBGYN residency and to Tufts for my maternal fetal medicine fellowship. And while I was faculty at Tufts, I got an MPH from Boston University with a concentration in health law, bioethics, and human rights.
And Dr. Carlson, are you board certified in obstetrics and gynecology?
Yes, and in maternal fetal medicine as well, which is a subspecialty of OBGYN.
With respect to maternal fetal medicine, can you describe for the court what the field of maternal fetal medicine focuses on?
Sure. Maternal fetal medicine, a maternal fetal medicine doctor takes care of pregnant women who are having medical complications to their pregnancy, such as preterm labor or preeclampsia. We take care of pregnant women who have medical diseases that are complicating their pregnancy, diabetes, artificial heart valves, hepatitis. We take care of women who have had bad things happen to them in previous pregnancies. They've had blood clots or stillbirths or early delivery, and provide counsel and care for them. And then another large part of what we do is that we help women assess the health and well-being of their pregnancies through ultrasound, other radiologic studies, and sometimes invasive procedures like amniocentesis or chorionic villus sampling.
Dr. Wilson, how is a maternal fetal medicine specialist different from someone who's a general practice OBGYN?
We are required to complete a fellowship after our 4 years of OBGYN training, and that's currently a 3-year fellowship.
And Dr. Ralston, are you a member of any professional medical associations?
Yes, I'm a member of the American College of OBGYN and the Society of Maternal Fetal Medicine.
Have you held any leadership roles in any of those organizations?
Yes, at the American College of OBGYN, I was on both their ethics committee and their genetics committee, and I chaired both of those committees for a number of years. At the Society of Maternal Fetal Medicine, I was on their guidelines committee, helping write guidelines for to distribute to our profession.
And I'd like to bring up plaintiff's exhibit 10. Dr. Ralston, and Your Honor, this is what's been marked as plaintiff's exhibit 10. Dr. Ralston, do you recognize this as your curriculum vitae?
I do, yes.
And is if I call it a CV, is that okay?
Yes.
And is your CV an accurate summary of your educational and professional history, your publications, and other credentials?
Yes.
And Dr. Ralston, does this appear to be a true and accurate copy of your CV?
I'm sorry, I missed that.
Does this appear to be a true and accurate copy of your CV?
Yes, it is.
All right, Your Honor, plaintiffs would now seek to move exhibit 10 into evidence.
No, you're not. One question, smart confidential at the top. There's some confidentiality in this. Just want to make sure we don't put something into public record. Some are confidential.
I will double check with Dr. Ralston that there's nothing on here that needs to be kept confidential. I believe it was part of our production of expert materials that have been marked confidential.
But we'll need to redact anything before it's part of public record. Sure that you.
Understood. Thank you. Dr. Ralston, you touched on this briefly, but could you please describe to the court your experience, your personal experience in providing abortion services to patients?
Sure. I have always thought of abortion as being part and parcel to part of the obstetrics package that I am bringing to the table when I'm caring for patients. There are patients who come to me for obstetrical care who then have things arise in their pregnancy that make them decide to seek abortion care. There are patients who come to me directly seeking abortion care from me. It has been part of my clinical practice for 30 years.
And approximately how many women have you provided abortion care to over the course of your career?
It's a hard number for me to estimate accurately, but I would say it's on the order of many hundreds to just over 1,000, perhaps.
Dr. Ralston, did you submit an expert rebuttal report in this case?
I did.
Can we bring up plaintiff's exhibit 9, please? Dr. Ralston, does this look to be the expert rebuttal report that you submitted in this case?
It is, yes.
And plaintiffs would move to admit exhibit 9, the expert rebuttal declaration of Dr. Stephen Ralston into evidence.
No objection.
Dr. Ralston, what are the opinions expressed in your expert report?
I'm sorry, I missed that again.
What are the opinions expressed in your expert report?
Did you say the views expressed?
Opinions, but
Opinions. So my opinions are that the opinions of the experts on the other side are inaccurate in many ways, especially in terms of the safety of abortion care. I also disagree with their experts on the clarity of the bill in question, SB 2023, I think is the number. And their assessment of what abortion is in the panoply of care that we provide to obstetric patients. I think their experts claim that abortion is not healthcare, and I vehemently disagree with that. And it's been a very important part of the care that I've provided to pregnant women for 30 years.
Your Honor, at this time, plaintiffs tender Dr. Ralston as an expert in obstetrics and gynecology the provision of abortion and the safety of abortion care.
Any objection? So.
Dr. Ralston, as a physician, are you familiar with the term healthcare?
Yes, I am.
What does the term healthcare mean to you as a physician?
Well, I went into medicine to provide healthcare and to improve people's lots. And I became an OBGYN because I wanted to do that in the realm of obstetrics and gynecology, and then later, of course, in high-risk obstetrics. To me, providing healthcare means taking the individual who's in front of me and getting them from point A to point B in the safest way possible, consonant with their particular needs and desires. And that involves medical treatments often. It involves diagnostic assessment of what's happening to them. It involves counseling and care and psychological support. It involves making sure that they have everything that they need at home to take care of themselves for a pregnancy, whether that be equipment or social services, transportation to and from their appointments. So it's a wide range of things that I think define healthcare, certainly in my job.
In your expert opinion, is the provision of healthcare limited to treating physical ailments or illnesses?
Yeah, I think that view of healthcare is an antiquated view, that there's so much more that goes into the health of an individual than just whether or not they have an infection or a heart that's not working properly, that there are social and emotional and familial and structural things in their lives that are impacting the ultimate outcome, which is good health or bad health.
And is abortion part of healthcare?
Yes, it is.
Why?
Well, for a number of reasons. First of all, I think if you were an outsider looking in on an abortion procedure, it would look like many procedures that we perform in clinical medicine. It looks exactly like the care of a miscarriage. We use the exact same tools, instruments, sterility, equipment, medications, techniques, ultrasounds, support staff, nurses, anesthesiologists, all look exactly the same when you are comparing a miscarriage care to abortion care. I think it's also clearly healthcare because we require medical students and residents and fellows to learn about this so that they can either provide the care themselves, or if they're not going to provide it, to at least counsel patients about the risks and benefits and alternatives to continuing or not continuing pregnancies. So like many other things that we do in medicine, it has all the trappings of healthcare.
And if a patient is seeking an abortion for reasons unrelated to her physical health, would you still consider that abortion to be healthcare?
Yeah, because I think that patients seek care for many reasons other than their physical health. For example, women go to psychologists for mental health reasons, and to separate the mental from the physical makes no sense to me. So if a woman is seeking an abortion for mental health reasons, or because of emotional reasons, or financial reasons, or economic reasons, or whatever reasons that she may have, I think that is still the same health care that we are providing if that was an abortion to save her life.
Dr. Wilson, do you have an opinion about the safety of legal abortion procedures in the United States?
Yes, I do.
What is your expert opinion regarding the safety of legal abortion in the United States?
This is a very common procedure in the United States, and it is one of the safest surgical procedures that we have in the United States. When you compare abortion to other common surgical procedures, it is as safe, if not safer. And certainly when you compare abortion care to proceeding with a pregnancy and childbirth, it becomes very clear that abortion is much safer than continuing a pregnancy, and especially when you compare early abortion to continuing a pregnancy.
Dr. Ralston, you mentioned the safety of surgical abortion. Do you have an opinion on the safety of medication abortion?
Yeah, I think the data on medication abortion is just as reassuring as the data on surgical abortion.
And what is the basis for your opinion that fetal abortion is extremely safe?
So the basis of my opinion is my experience in this field. I've been reading and studying and learning about obstetrics and pregnancy for 30 odd years now. My understanding of the literature and the scientific basis for determining the safety of medical procedures, it seems very clear to me that abortion is an extremely safe procedure. And then my practical experience as a provider of this care and working in hospitals, working in clinics, is that women do not end up very ill after abortion procedures. They don't end up in intensive care units. They don't end up getting blood transfusions very often. They don't end up with complicated surgeries, and they don't end up dying from abortion procedures, as opposed to women coming in and having medically complicated labors and deliveries, which can lead to quite significant morbidities and mortalities for women. I've seen many, many more patients end up in intensive care units after having a baby compared to women who have had abortions. In fact, I can't even remember the time that I've seen a woman end up in an intensive care unit after an abortion. And yet I currently have 3 women in my hospital who have had babies who are in the intensive care unit, because that is the time that women really are at risk.
Ralston, you mentioned the scientific literature that you're familiar with about the safety of abortion. Are you familiar with the National Academies of Science, Engineering, and Medicine study from 2018 on safety and quality of abortion care in the United States?
Yes, I am.
You could bring up listed exhibit as plaintiff exhibit 19. Dr. Ralston, is this the National Academy? I'm going to call it National Academies for short, if that's okay with you.
Sure.
Dr. Ralston, is this the National Academy study that you mentioned in your testimony?
Yes, it is.
And what was the primary conclusion of this study?
Well, this was a group of experts who got together to answer a number of questions about abortion care in the United States. And one of the questions that I think is germane to this discussion is whether or not abortion is safe. And their conclusion was a resounding yes, it is an extremely safe procedure.
And how does the conclusion of the National Academies compare with your experience as an OBGYN and an MFM?
It was completely consistent with both the science and literature that I knew on this topic before this study came out, and completely consistent with my personal experience in providing both abortion and obstetrics care.
And are you familiar with the analysis and approach to research taken by the National Academies in putting this study together?
Yes.
How did you become familiar with the analysis and approach taken by the National Academies in this study?
Well, I think like any scientist, when I look at a study, the first section that I read is the methodology, because I want to know how they came about doing this study and what techniques they used to make sure that they were producing sound conclusions. And so I read the methods in this study to familiarize myself with that. And this was a systematic review. So these experts went and cast a very wide net for the various questions that they were trying to answer, and looked at all the research that had been done in those areas, and then looked at the studies and made sure that they were only including studies that were methodologically sound, that they were well controlled, well thought out studies, and that the data that they were looking at was relevant to the questions that they were trying to answer.
Dr. Ralston, with those methods in mind, what is your response to the allegations made by independent experts that the National Academy has failed to include research that contradicted its final conclusion about the safety of abortion?
So I I see no evidence for that. I see evidence that the National Academy may have rejected studies that they did not think were methodologically sound, that were not based in good scientific rigor, or did not have conclusions that were well-founded based on the data in those studies, but not that that would because of bias.
How do you respond to defendants' experts' allegation that the National Academy's research is based in pro-abortion bias?
I see no evidence of that in this review.
What is your expert opinion on the safety of abortion as compared to carrying a pregnancy to term?
I think it is very clear from the data that exist in the scientific literature, as well as from my own personal experience, that abortion is an extremely safe procedure, whether it's done surgically or medically, and even into the second trimester, it is safer than childbirth.
And are you aware of defendants' experts' opinions about the safety of abortion?
Yes, I am.
What is your response to defendants' experts' claims that abortion is not significantly safer than carrying a pregnancy to term?
Well, I think that they are ignoring the preponderance of the well-designed studies that are out there and the well-designed reviews that are out there. I think that much of their conclusion is based on studies that have been shown to be biased in their design, and that has led to erroneous conclusions.
Are you familiar with the rates of complication associated with abortion as compared to the rates of complication associated with pregnancy?
Yes, I am.
How do defendants' experts' claims that abortion complications are underreported affect your opinion on the safety of abortion as compared to the safety of pregnancy?
I think any study that's trying to assess some complication rates has to be concerned about underreporting of complications, but I see no reason to think that abortion care complications are underreported any differently than childbirth care would be underreported. Moreover, for the complications that we are most concerned about, let's say mortality, I think it's very unlikely that we are going to be missing women who are dying from these procedures, because they are going to become very obvious to the people who are caring for them and for the hospitals where they present. And our ability to detect pregnancy as being related to a mortality event in the United States has improved tremendously over the past few decades. And it's now required on death certificates that there be a checkbox if a woman had been pregnant in the previous year.
Dr. Wilson, what is your response to the claims that certain studies have found a link between abortion and adverse mental health outcomes?
The claim that those studies exist is a true claim. There are studies out there that have that claim. I think most of those studies have been debunked, mostly because they are really fraught with biases in their design, primarily recall bias, where you ask women who have mental health problems if they've had abortions, and they will often say yes, compared to women who don't have mental health problems, who may not want to tell you about their abortions.
And Dr. Wilson, what is your response to claims that certain studies have found a link between abortion and breast cancer?
I think it is also fraught with the same problems, and then the bulk of the data that we have on well-designed studies in this area has not found that link.
And how does that square with your understanding of the biology involved in both pregnancy and breast cancer?
Yeah, so if you're going to say that something is causing something like breast cancer, you want to have a clear biological plausibility to that analysis. And I've just never been that impressed with the biological explanations. Moreover, you also want there to be a dose response, that if you think that like drug A causes cancer B, then more of drug A should cause more of cancer B. And there's zero evidence that multiple abortions leads to more risk of breast cancer. So that to me is damning to this whole line of reasoning about the link between abortion and breast cancer.
Dr. Ralston, are you aware that in this case, plaintiffs are challenging Ohio Senate Bill 23?
I'm sorry, could you say that again?
Are you aware in this case that plaintiffs are challenging Ohio Senate Bill 23?
Yes,
If I call it SB 23, you'll know what I'm referring to.
yes,
Have you reviewed the text of SB 23, Dr. Ralston?
I have.
And have you reviewed the provisions of SB 23 pertaining to the exceptions under which an abortion may be performed after the detection of fetal cardiac activity?
I have, yes.
Have you reviewed the Ohio Attorney General's quote-unquote explainer on the exceptions to SB 23?
I have, yes.
In your professional medical opinion, do these exceptions provide sufficiently clear guidance to physicians on when it is legal to perform an abortion after the detection of fetal cardiac activity?
I do not think they are sufficiently clear, no.
And why not, Dr. Ralston?
For a couple of reasons. One, I think the most important reason, I think that the language therein is vague. They use terms like serious and substantial that I think are not well defined in the statute. And moreover, they list some medical conditions under which the statute would not apply, but they don't list a lot of other conditions. And therefore, the question arises, I think, in many physicians' minds is the abortion that I want to perform going to be legal in the state of Ohio?
Dr. Ralston, would consulting another doctor or a lawyer help answer that question that the physician may have?
So let me take each side of that. Consulting another physician, I think, is not going to help you, because if you're a physician and you can't interpret the statute, I'm not sure why another physician would be able to do that any better. We are not lawyers, and that is not our area of expertise. Second, if we ask a lawyer, the most likely lawyer we're going to ask is somebody who's in our risk management office in our hospital. And those lawyers are very conservative, and they are almost always going to decide on the hospital and protecting the hospital. And they're almost always going to say, don't do the abortion, because they don't want to put the hospital at risk. So I'm not sure that consulting a doctor or a lawyer is going to help you. Moreover, just doing that is going to delay care, which I think is often not in patients' best interests.
And in your professional medical opinion, will a physician's reliance on the standard of care resolve these concerns about the ambiguity in SB 23's exceptions?
Well, I think it's very difficult to know what the standard of care is when you have a statute like this. And when the standard of care has been to provide abortion services when patients request abortion services, and you can no longer do that, I think that doctors don't know what the standard of care is in Ohio anymore. And that can be really frightening, I think, for physicians not to know if what they are doing is going to be prosecutable.
And you mentioned that, Dr. Ralston, are you aware of what the penalties are for violating SB 23?
I remember reading them, but I, for the life of me, I can't tell you exactly what they are.
Are you aware that it involves criminal penalties?
Yes.
So does the fact that criminal penalties are on the line factor into the decision-making of the physician who might be faced with providing an abortion under an exception to SB 23?
Yeah, I mean, I can't get into the minds of future physicians in Ohio, but I can tell you that I know that we think about this as physicians when we are providing care that might or might not be legal in the states that we are working in. I certainly talk to my colleagues in other states where abortion has been restricted, and they are very worried about this. These are their medical license and their livelihoods that are on the line. These are usually the major breadwinners in their families. They are paying for mortgages, paying for tuitions, and risking their careers for this issue is really difficult for doctors.
Dr. Ralston, in your opinion, are the exceptions to SB 23 sufficient to protect the health of the pregnant patient?
I do not think they are sufficient, no.
So just in short, Dr. Ralston, in your expert opinion, is abortion healthcare?
It is absolutely healthcare. I provide healthcare every day, and abortion is one of the tools that I have in my toolbox for caring for women who are pregnant.
And in your expert opinion, is abortion a safe procedure?
It's extremely safe, especially when you compare it to childbirth.
And finally, in your expert opinion, as a physician who performs abortions, are the exceptions to SB 23 clear?
They are not clear, no.
Nothing further on. Good almost afternoon, Dr. Ralston. My name is Amanda Naylor, the Attorney General's office. Can you hear me okay?
Yeah, I think if you speak just a little closer to the mic, it will help.
Good question. The problem is the boom mic is sitting below the TV. The microphone's not work, right? You're trying to move the boom mic out for the good sake of things like this. You know what I'm saying? So move forward, but the sound is never a goal plus around this whole.
I think it's so needed. I do have actual. We're working on that.
Can you hear me okay?
Yes, thank you.
Great. Dr. Wilson, you aren't licensed in practice medicine in Ohio, right?
No, I am not.
As to your view of what healthcare is, when you say that you want to perform these procedures in the safest way possible, you mean for the pregnant woman, right?
I'm sorry, could you say that again?
So when you were talking about healthcare earlier in your testimony, you said that you strive to provide abortion care in the safest way possible. And that is for the pregnant woman, correct?
Yes.
And you said that from the outside looking in, if anyone were to view an abortion procedure, it would look like treating a miscarriage, right?
Yes.
And many other medical procedures, correct?
Well, I think that the procedures that we use in abortion care are the exact same procedures we use in miscarriage care. That was my point.
But they're not the same, are they?
They are absolutely the same. They use the same medications, the same techniques. If I am evacuating a uterus where the fetus is no longer living, it's the exact same procedure that I use to evacuate a uterus that the fetus is living. There's no difference whatsoever in that procedure.
But you just identified the difference there, that when you treat a miscarriage, the fetus has died of some natural cause or some other cause other than the doctor causing the death of the fetus, correct?
I think that that distinction is what I'm saying, is that the distinction is then that whether or not the fetus is alive, and that the care is actually exactly the same, because how you get the pregnancy out of the uterus does not differ between those two. That's why it seems like healthcare to me.
So the difference then between treating a miscarriage and performing an abortion is the intentional causing of the death of the fetus, correct?
Can you say that one more time, please?
So the difference between treating a miscarriage and treating a patient with an abortion procedure is the intentional death of the fetus caused by the doctor, correct?
I disagree with that, actually. I think the intention in the abortion procedure is to evacuate the uterus and take the contents of the uterus out. Unfortunately, the fetus is going to die during that procedure. That is not the intent of the procedure, however.
So the intent of the procedure is not to cause the death of the fetus and the pregnancy.
The goal of abortion care is to take a pregnant woman from the pregnant state to the non-pregnant state. It is often to evacuate the uterus or give medications to cause miscarriage.
But the reality of it is that in order to take her from a pregnant state to a non-pregnant state, you have to cause the death of the fetus. Is that not correct?
That is unfortunately correct, yes.
Is it your testimony here today that women never die from abortion procedures?
My testimony today is that women die very infrequently from abortion care, and women are much more likely to die from having a baby, childbirth, than from an abortion. That is my testimony.
But women can die from abortions, correct?
Women can die from almost any medical procedure that you can name.
And women have died in abortion procedures. Is that not correct?
I'm sorry, can you say that again?
And women have died as a result of abortion procedures. Is that not correct?
Yes.
And as a doctor, are you able to determine if a patient is at risk of death?
So I am able to determine the kinds of medical problems that might make a procedure or a delivery or anything that I'm doing to a patient more or less risky.
So if a patient presents with a particular set of symptoms that in your reasonable medical opinion could cause her death, is that sufficient, do you think, to make the determination that she's at risk of dying?
So everybody's at risk for dying, and everybody's at risk for dying from medical procedures. And what we do as clinicians is determine what those various morbidities that women have that might be impacting their risk of dying or having any kind of complication from a procedure, and then counseling them about those risks. And that may have an impact to them on whether or not they want that particular treatment or medication or surgery.
And aren't you trained to make those kind of determinations as to how great the risk of death might be for any type of condition or procedure?
That's exactly why my opinion is that abortion is safer than childbirth, because I am trained to make that assessment.
So you can say that abortion is safer than childbirth, but you can't determine whether a condition under this law would be within an exception that allows for an abortion when the mother's life is at risk.
So I think that what I said is that the language in the statute is unclear, because there are words like serious that I think the legislature has put in there that I'm not sure what that means. And I'm not sure who's going to make the determination of what is serious. I think the word substantial is in that statute as well. And I'm not sure who gets to determine what that word substantial is. Is it me? Is it the patient? Is it the district attorney? I don't know the answer to that. And that to me is what is difficult about this statute for me as a physician who's trying to care for the patient in front of me.
And just so we're clear, you don't practice medicine in Ohio.
I don't think I need to practice medicine in Ohio to understand how a physician in Ohio might feel. I am a physician. I've practiced in Massachusetts. I've practiced in Connecticut. I have practiced in New York. I have practiced in Philadelphia. I have practiced in Maryland and DC. All of these places have very different abortion statutes. And I know the anxiety that it can create in a physician.
If you could please answer the question that I've asked. Again,
Just to let the witness finish, I believe he wasn't done with his answer.
I would ask you to answer my question, with your response to the question that I've asked.
Will be strong. You ask a question, you take the answer. Go ahead. Go ahead.
Dr. Wilson, would you like to finish your answer?
I think the place that I was going with that answer is that because I have practiced in these many places, I think it gives me some ability to conclude what it might be like to practice in a place like Ohio that has abortion statutes as well. Physicians are physicians, and they behave the same in almost every place that I've worked. And our reaction to legislation and restriction and regulation is very similar.
But the question I asked you is, you don't practice in Ohio, do you?
I don't think I need to practice in Ohio to make a conclusion about how a physician in Ohio might react to this statute.
Dr. Wilson, I'm not asking you about how a physician might react. I'm asking you if you practice medicine in Ohio.
I do not know.
And you're not licensed to practice in Ohio.
I do not. I am not licensed in Ohio, no.
No more questions, Your Honor. Thank you, Dr. Wilson.
Any redirect?
No redirect.
I don't know if the doctor can hear me, but we thank you for his time. Please excuse.
Thank you very much, Judge.
Thank you, Dr. Wilson.
All right. This is a short break. Council agree.
Yes,
We set for about 15 minutes. We'll see you at 5.
thank you.
Got it?
Mic check, 1 2, check. Check, check. Check, check, 1 2.
There's concern about with the microphones.
Yes.
The whole one didn't work there. Because the first one did not.
Okay.
But I'm not worried about that.
Will be for the state defendants to mind if I do my for the state's case now for the call.
Okay, we're going to go down to her. There we go.
Yeah, after all, things of the following, when you run all of that, you need to do.
Go ahead.
Morning, Your Honor. My name is Andrew McCartney, and I will be providing a brief open statement on behalf of the state defendants. In this case, plaintiffs bear the burden to establish by clear and convincing evidence that 1, they will likely prevail on the merits, 2, that they will suffer irreparable harm absent the injunction, 3, that no third parties will be unjustifiably harmed if the injunction is granted, and 4, that the public interest will be served by the injunction.
Regardless, whoever's machines are going off, that's a 101. Okay. If your phone is not silent, silence is now. Regardless, trying to set it open. You're here as privilege, and the rest. You can't control your equipment, leave now. All right. Very good. Go ahead, Mr. McCartney, very soon.
Thank you, Your Honor. Plaintiffs have not established any of the requirements for a preliminary injunction here. First, and I will not belabor this point at all, plaintiffs will not likely succeed on the merits for the reasons stated in the state defendant's brief in opposition to plaintiff's request for a preliminary injunction. I'll focus the rest of my brief time on the failure to establish irreparable harm, which Ms. Diamond addressed with regards to irreparable harm from the plaintiff's perspective. If plaintiffs cannot establish irreparable harm by clear and convincing evidence, the court may not consider the remainder of the elements. As to the clinics, a monetary claim will not support a finding of irreparable harm. And plaintiff's motion requesting a TRO to be followed by a preliminary injunction focused a lot on the alleged imminent closure of the Dayton clinic, which is owned by one of the plaintiffs in the case, Women's Med Corporation. Plaintiffs decided not to call Dr. Haskell, who's the owner of the Dayton clinic, to testify today. Had plaintiffs called Dr. Haskell as a witness, the state defendants would have had the opportunity to cross-examine him on financial information regarding the Dayton clinic obtained through witness discovery. Plaintiffs have failed to establish the imminent closure of the Dayton clinic, which was a major basis for the motion for a preliminary injunction. Although the state defendants do not bear the burden here, the court will be hearing today from the state defendants 3 expert witnesses whose testimony further undermines plaintiffs' claims in this case. The first will be Dr. Dennis M. Sullivan, who has a graduate degree in bioethics and moral philosophy, as well as a medical degree. He will explain the problem of plaintiff's assertions from a medical ethics perspective. The second will be Dr. C. Brent Bowles, who will discuss the complications that can occur with abortions, as well as some of the reasons why abortion complications are likely underreported. Dr. Bowles will also discuss the negative physical and mental health impacts that abortion has on women. And finally, Dr. Michael Parker, an Ohio physician with decades of experience in obstetrics, will explain that the Heartbeat Act imposes appropriate requirements that can be easily understood by a competent physician, and that a competent physician would be able to determine when the Heartbeat Act's exceptions apply. For all those reasons, state defendants would ask the plenary injunction to be denied. Thank you.
Call Dr. Dennis Sullivan to the stand.
You raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Speak loudly into the mic.
Good afternoon, Dr. Sullivan. Would you please state and spell your last name for the court reporter, please?
My name is Dr. Dennis Michael Sullivan, Sullivan.
And are you a medical doctor?
Yes, I do.
Did you provide an expert report in this case?
I did.
I would like to show Dr. Sullivan what defendants have marked as Exhibit H. Dr. Sullivan, what is this document that you are looking at now?
This is a copy of my expert report that I submitted and a copy of my CV.
And Dr. Sullivan, is that a true and accurate copy of the report you submitted in this case?
It appears to be.
Your Honor, we'd like to move that this exhibit be entered into evidence. There you go.
All right, so then.
So the state has asked you to provide expert testimony here today regarding the Human Rights and Heartbeat Protection Act, which I will refer to as the Heartbeat Act. Are you familiar with the Heartbeat Act?
Yes, I am.
And are you prepared to testify regarding your expert opinion in this case here today?
Yes, I am.
So before we get to your opinion, can you tell the court about your educational background?
Yes. I trained in chemistry at Youngstown State University, graduated in 1974. I achieved my MD from Case Western Reserve School of Medicine in Cleveland, and I received that degree in 1978.
And what work have you done since completing your degrees?
I've been trained in general surgery, first University of Kentucky in Lexington for 2 years, and then completed my training here in the Miami Valley in the Red State General Surgery Program, training which I completed in 1983.
And then what did you do in your career?
After that, I became board certified in general surgery. During my surgical practice at the Blanchfield Army Hospital as an active duty member of the U.S. military for 2 years in Fort Campbell, Kentucky.
And to say thank you for your service, Dr. Sullivan. What is your current position?
Well, after a lot of other changes, I've ended up with an academic career since 1996 at Cedarville University, where I have initially taught human anatomy and physiology, and then achieved a graduate degree in biomedical ethics, which I completed in 2004. I then started the Center for Bioethics at Cedarville University, which I directed until my retirement in 2019.
And what do you do now?
Well, in the time intervening, I have done additional work. I have served on 3 different hospital ethics committees in the Miami Valley. I continue to serve on the Premier Health Ethics Committee, which is a number of hospitals associated with it. I've written a book on pharmacy ethics, which was published last year by Springer Publishers. I continue as actively write and research in medical ethics. I'm the editor or reviewer for 3 different academic journals, and still do a lot of teaching part-time. I've also taught at the Utah School of Medicine in the Dayton area, and continue an active part-time teaching career.
So in total, how long have you been active in the bioethics field?
Well, I've been a physician since 1978, and every physician has to deal with ethical questions. But in the additional specialty training in medical ethics since 2004, I completed my degree. Of course, I was training during that period of time. So I would say that in all, I've been active in ethics in one way, shape, or form since 1978 in a directed academic way since about 1999 when I began my advanced studies.
Do you teach medical ethics to students?
Yes, I do, in a number of different venues.
And how long have you been teaching medical ethics to students?
I've been teaching medical ethics since about 2003.
Have you ever acted as a medical expert in the area of medical ethics in abortion-related matters?
Yes, I have.
And what were those matters?
In 2018, I worked with the Ohio Attorney General's office with a lawsuit against the a bill that was passed and targeted against abortion for Down syndrome. And that was before the 6th Circuit Court of Appeals.
And have you done any other work on abortion-related matters related to medical ethics besides your in this case?
Yes, I have. I also worked in the state of Tennessee in 2020, where I've written expert testimony on with regard to their abortion ban bill. That bill, my particular part was broader bill, but my particular part of that was related only to the issue of abortion for Down syndrome.
So just to clarify, in both of those cases that you rendered a medical ethics opinion, in those cases involved state laws or statutes that were being challenged that regarded abortion.
Yes.
And in those cases, how did your opinion relate to medical ethics?
Well, in those particular cases, there was the issue of the unborn fetus and its proper protections and violations of non-maleficence, one of the prime principles of medical ethics, and also violations of distributive justice because of the way that a particular genetic variant was being attacked unjustly. And so my testimony related to those main biological principles.
So let's talk for a minute about your qualifications. Have you written any articles related to medical ethical implications of abortion?
Yes, I have.
And what articles have you written? How many?
I've written on the broader aspects of the abortion case generally, I believe 4 major articles that review the nature of the unborn fetus and its status as being a human being.
And what do you mean by status?
Its moral status. It's there is a conflict in the way terminology is used in this matter. And I specifically commented on the fact that the unborn fetus is human, and that's a biological fact. The idea that, this is commonly represented, that nobody knows when human life begins is patently false, because it is clear from biology, and in particular embryology, that human life indeed begins at conception. And so therefore, my articles highlighted that scientific fact, and then made further claims about the moral status of the unborn that arise from that scientific.
So what is the basis for your determination that human life begins at conception, factually?
From science, we know that there are haploid entities, the ovum and the sperm, that don't have the full component of human DNA, they don't have the full number of chromosomes. So therefore, they in no way represent unique entities that have organismal status that exist independently of the self-directed movement. When those 2 entities join together at the moment of fertilization during human infancy, then we have 46 chromosomes, and so we have all of the necessary material that establishes that moment when that entity becomes an organism, becomes a human organism. So therefore, scientifically, medically, we know that human essence, the human nature, begins at the moment of conception. And that's scientifically not open to any debate. That's simply a scientific fact. And so we can build a case as to whether or not we're going to confer moral protection or moral status for that entity based on that given fact. But it begins with the science that the new entity, the embryo, which is, it's an embryo up until it meets, and after that it becomes a fetus in terms of scientific terminology. The initial entity group is a one-celled embryo called the zygote. And so any of these stages represent a new human organism that has its own self-directed movement and needs nothing to become an adult member of our species except time, protection, and nutrition.
Is there any current literature related to abortion similar to those involved in this case?
Yes, there is.
And did you review any of that current literature in preparation for this case?
Yes, I have.
And what was the literature that you reviewed?
Well, I looked at a number of studies. I did a review through PubMed analysis, and Google Scholar, and other ways of sorting through that. And I weighed and I looked at the various forms of evidence that would affirm what I just said in terms of those facts. There are a number of scholars that I've come to rely on that have helped to teach those facts to me. I did teach embryology and developmental biology at Cedarville University for 10 years, so I'm very familiar with the literature that relates to this.
Now, on that point about the embryology and the scientific fact of the humanity of the newly created fertilized cell, is there anyone that disagrees with your view that it is a fact that a new human is created in that process?
That's an interesting question that's hard to answer because scholars that I've consulted with, for example, Dr. Maureen Condon, who is an embryologist from the University of Utah, has written extensively on these matters. Dr. Robert George from Princeton has written on these matters. And they agree with the conclusion that I've learned from them, that we can define human life in this biological scientific way. The problem is when we conflate the idea of human life and say that we're talking about something else, which is human moral status. Moral status, they posit it's different than human life. And we would simply say that human life is human life, and therefore warrants our moral consideration. Those who try to separate that may still say that we don't know whether or not human life begins in conception, but they're conflating two different kinds of concepts. They're saying that there should be an alternative moral status to that early entity. We would simply say that's not our opinion.
So did you have the opportunity to review documents related to this case?
I did.
And did the state provide you with documents to review in this case?
Yes, I did.
What were those documents?
I reviewed the pleadings from the various parties that were bringing the lawsuit here, and I reviewed the answer given by the state in regard to those pleadings. I also read the order, the temporary restraining order that was given by the judge in this case.
And what documents did you review other than those documents in drafting your expert report?
Oh boy, I used a lot of the research that I've looked at over the years. It would be very hard for me to summarize the extent of the documents I reviewed and examined and sifted through and writing my report. I've tried to focus primarily on the areas of biomedical ethics that arise out of medical principlism, which is the way that we do medical ethics. And I've tried to focus on those issues that I've just related to you with regard to the nature of human life. So I spent a lot of time searching through a lot of documents. I've looked through some of my old writings that I have produced and some things that I'm still working on. So it's hard to summarize in any concise way the number of documents that I sent.
But the documents that you actually used to draft your opinion, are they cited to in your opinion?
Yes, they are.
Okay. So how did you choose what to review?
I tried to look at scientific work that relates to the question that I've already offered in testimony. I've also tried to look at the nature of medical ethics. That's something that's very easy to research because of Beechman Childress principles of biomedical ethics. The division is really the standard guide for biomedical ethics. I also reviewed Johnson, Winsley, and Sigler, which is a clinical ethics textbook that looks at the issues in the same foundational way. I've examined documents current documents that relate to medical ethics. I've also looked at the complex and hard to research question of outcomes after abortion, because those were part of the pleadings in this case. And so I concentrated my efforts on studies I thought had further probity for this matter, because they were larger studies, ones that didn't have some of the possible defects of what I found in the pleadings cases, and meta-analyses that look at taking a large number of studies and putting them together to reach more certifiable conclusions.
And what did you conclude after reviewing all the relevant documents that you reviewed?
Objection, Your Honor, has the witness qualified as a witness at this point, and if so, in what subject matter?
I believe that the council has asked the court to accept this.
Your Honor, we would move the court to accept Dr. Dennis Sullivan as a biomedical ethics expert in this case.
Any objection?
Objection, Your Honor.
So,
And what did you conclude after reviewing all of the relevant documents that you reviewed in this case? Yes.
So, the report. In summary of my conclusions, I have stated that the requirement of an ultrasound examination to determine the presence of fetal heartbeat is reasonable, it's consistent with good medical practice. Furthermore, based from medical ethics broadly understood through the standard of medical principlism, would say that individual personal autonomy should not be observed above the duties of beneficence and non-maleficence required in the medical profession. I believe the state of Ohio does have a rational basis for limiting the invasive procedure of abortion to cases of true medical necessity. I also believe that claims of serious harms to women with those sex limitations are hypothetical and vague. I would say that the state, in overall summary, as a matter of mere prudence, has a compelling interest in protecting the lives of young women. And the heartbeat law is a reasonable limitation on the medical community and on patients.
So let's talk about some of those terms so that we can understand what you're describing in your opinion. So can you tell us what principalism, as you described it?
Yes, once again, allow me to even to report.
I believe you began speaking about that issue in paragraph 14.
Yes, that's just where I left. And so we had an ancient framework of the practice of medicine ethically that goes back 2,400 years, goes back to Hippocrates. And from that tradition, which has become normative for medicine, we have these ideas that become standard practice. First of all, the profession of medicine depends on beneficence. We accept as given that the person in the white coat is acting in the best interests of the patient. We don't even think about that. That's a legacy of those many years.
Could you tell the court what beneficence means?
Yes, beneficence means simply that a physician should always act in a patient's best interest.
And what are the other principles of medical principles?
Perhaps a more familiar principle for this long tradition is the do no harm principle, which is non-maleficence. Is that healthcare professionals should not cause harm to their patients.
Is that where the Hippocratic Oath comes from?
Well, Hippocratic Oath actually begins with beneficence. It begins with that standard, which in the history of 400 BC was a new standard. It was a minority view that became the standard over the centuries. So out of that commitment to beneficence came the do no harm principle of non-maleficence. So they're paired, they're not identical, but they're paired.
And does the Hippocratic Oath and those principles have anything to say about abortion?
Well, they do because the original Hippocratic Oath, under the principle of non-maleficence, gave a specific example, and that was abortion was not permitted. So they actually specified that abortion was not part of a physician's medical practice.
So what are the other principles of principalism?
The third principle that comes out of the Hippocratic Oath is distributive justice. And some would argue that a full-blown modern idea of justice is not contained in the oath, and that would be accurate. But there is the idea that physicians should not abuse patients based on their gender or even their status as slaves in the sick room and in the private counseling room, which is really the first statement in history of this idea. The idea of justice has been specified since then in medical ethics as distributive justice, which we now recognize as the equal distribution, equal doling out of the benefits of medicine to each and every member of our society, regardless of that long list of things that we always put in there, gender, ability to pay, age, race, religion, and all of those other things that are not related to healthcare in any direct way.
So what is autonomy within this subset of principles?
Autonomy was not part of the original Hippocratic Oath. The idea of autonomy came into understanding in the 18th century during the European Enlightenment under the German philosopher by the name of Immanuel Kant. And it's the idea that autonomy means that patients can make their own decisions, or I should say, this is a service, and the patient is unable to make decisions for him or herself. But that patients in the service should be able to make their own decisions about healthcare. And so that's a more recent development in medical principles. So all of these things taken together make up these prima facie rules that we now understand as medical principles.
And what do you mean by prima facie?
I use that term because the rules are not intended as a dispositive principle that is rigidly applied in every case, because they have to be weighed and balanced. And so in our modern context, some people would take one rule and try to rigidly make it apply to all others. Prima facie simply means, from the Latin of first face or first appearance, it simply means as we first look at a case, we recognize that there are duties that arise out of these principles. But then you have to take each duties, rather than rigidly applying them, you have to weigh them against each other. You have to specify which duties apply in a given case. Not all cases, for example, will involve distributive justice, especially if you're dealing with one particular patient. But there may be justice issues that are also coming to bear. But in our discussions about the abortion issue, clearly the principle of autonomy is often seen in conflict with the principle of non-maleficence.
So does one of these rules take priority when you're making these kind of weighing and balancing determinations?
Well, that's where medical ethical judgment comes in, where you have to see legitimate claims of autonomy and legitimate concerns about non-maleficence. For example, we make that kind of claim all the time. In a case where, from my profession of general surgery, where an operation is clearly indicated, and the patient understandably says, "Doctor, will it hurt?" And I said, "Well, yes, it will hurt, but it will be for this greater gain." So there is this idea of not doing harm. Well, there's kind of a targeted harm, it's limited harm, but the benefit to be gained, the beneficence that we will offer that patient in terms of potential curative treatment will be realized. So there's an example of weighing and balancing these principles.
So you said that in the abortion context, that non-maleficence and autonomy conflict? How do they?
Well, the simple claim that a woman's autonomy should be the overriding principle here. It ignores this whole idea of the weighing and balancing of prima facie rules, because there is another human being present in that counseling, and that other human being deserves protection. And so if an abortion is contemplated, it should be only considered if there's no other way to help the woman who is dealing perhaps with a threat to her life or to her a major organ system, or some other grave harm that could befall her. And so if we're truly honoring these principles, then we need to consider the unborn as a vital, as even back in the ancient practice of medicine, that's why it was prescribed for physicians to do induced abortion. I'm not talking about miscarriage. I'm not talking about where a pregnancy loss has occurred and the physician is helping to help the woman recover from that unfortunate circumstance. So doing a dilatation curettage, for example, after a miscarriage, which is also called an abortion, but that's not an induced abortion, it's a spontaneous abortion. That's consistent with good medical practice, because the pregnancy has already not survived, so we're trying to maximize the benefit to the woman and help her recover from the circumstance, leading the products of conception in place in years could be very damaging to her, leading to infection, therefore they have to be removed.
So do other biomedical ethicists disagree with you on this point?
Other biomedical ethicists don't recognize the moral status of unborn in the way that I described it.
And can you tell us what moral status means again, so we can fully understand what you're saying?
Moral status is something that moral philosophers use, the phrase moral status, something that moral philosophers use. And the technical definition is, comes from the idea of a person. And so a person is a member of a moral community. That doesn't mean that we do moral acts. It means that we're members of those for whom moral consideration is due. And so members of the moral community, in my opinion, should include the unborn, as well as all of us that are cognitive and walking around.
So in your opinion, when does a fetus obtain moral status?
Fetus obtains moral status as a one-cell embryo at the same time that humanity is established.
So is there any weighing and balancing of these principles as it applies to the pregnant mother, the embryo, abortion?
Yes, there are indeed, because there are some circumstances where a pregnancy has no possibility of continuing. The most clear example on that is an ectopic pregnancy. Ectopic coming from two Greek roots meaning out of place. The most common way that an ectopic pregnancy can present is in the fallopian tube, whereas the embryo, unfortunately, did not completely reach the fundus, the top of the uterus, to implant about 5.5 days after fertilization, but instead something held it up along the way. Sometimes that's due to infection in the fallopian tubes or perhaps scarring, and then that embryo implanted in the tube. Now, that is a living embryo until about 8 weeks of gestation, when it will likely rupture, and that will cause a tearing of the ovarian artery, which will then cause massive bleeding and very commonly the death of the woman. So clearly, this is not, unfortunately, a human entity for which we can offer in hope of help. This is a terminal condition, if you will. And so therefore, we need to do the next best thing, and that is protect the life of the mother. And so it was always indicated to remove a two-whole pregnancy. The difference between that and abortion is that that was not a procedure where the intent is to cause the loss of life. The intent in that procedure is to save the life of the mother.
Mr. Your Honor, I'm more about the testimony provided by the witness is far outside of the scope of biomedical ethics and is relating to medical and scientific expertise.
Rules of evidence not apply for this. We'll order the testimony, whatever way this do.
So are there other factors that you would consider if the mother's life is in danger?
Well, there are other kinds of threats to a mother's life. For example, I've my experiences personally, I'm aware of some cases where a woman has had in the second trimester of pregnancy has had endometritis, which is an infection in the endometrium and in the placenta, which could cause sepsis, overwhelming infection, and cause her death. So in that circumstance, if that were the case, then doing an induced abortion has that purpose of saving the woman's life. Unfortunately, the loss of the fetus, because the goal is to save the woman's life rather than for two lives to be lost.
So expand on that, as you just stated, 2 lives will be lost. What does that mean?
Well, if that pregnancy were to continue under those unusual circumstances, excuse me, then both the fetus and the woman might die. So therefore, just the weighing and balancing tells us we need to save that woman's life rather than in that particular case doing what we can to protect the fetus. But that fetus, once again, similar to the case with the ectopic pregnancy, is not a fetus that we can successfully endeavor to help survive.
So when a woman's life is at risk, it's not a violation of biomedical ethics to perform an abortion in those cases. Is that your opinion?
It is not a violation of biomedical ethics under those circumstances.
What about in a case where the mother is at risk of substantial harm if the pregnancy continues?
Well, the law specifies that particular instance as well. And if a pregnancy has so threatened a woman's health, I remember one case in which I was consulted as an ethicist on was a woman in her 3rd trimester who had ruptured membranes 32 weeks, and so what should we do, because that's a risk to her for infection? Well, at 32 weeks, there's a good chance that fetus may be viable outside of the womb. So my recommendation, after consulting with the obstetricians in that case, was to recommend induction, that the labor be induced early so that the woman's life could be protected from the possibility of infection. So there's an example where you're weighing and balancing. That's not abortion, but it's an early delivery where we're doing this delicate balance of trying to protect the woman and the fetus both to the best extent of our ability.
So you mentioned the law. Are you referring to the Human Rights and Heartbeat Protection Act?
Yes.
And I will refer to that as the Heartbeat Act in this questioning. Have you reviewed that law?
Yes, I have.
What is your medical ethics opinion of the Heartbeat Act?
I could refer to my report again if I may. In my report, can you repeat your question, please? I'm sorry.
So what is your medical ethical opinion of the provisions of the Heartbeat Act?
Heartbeat Act says, and I'm paraphrasing here, Heartbeat Act says that abortion should not be performed unless if a determination by ultrasound is done and a heartbeat is present. So, and then it gives some exceptions, unless the life or the mother is at risk, or if there's a risk of serious medical harm involving the major organ system.
And does that violate any of the principles of medical ethics as you've explained them here today?
Not as I've explained them, because it represents that weighing and balancing that I've tried to represent today.
So you have discussed some of the exceptions that are provided in the Act. What is your opinion of those exceptions and from a biomedical standpoint?
From a biomedical standpoint, I'm not speaking as an obstetrician, so I cannot give a detailed expert opinion about each of those kinds of things. But the Heartbeat Act is very clear and says that competent physician can recognize such conditions as preeclampsia, inevitable abortion, and I have given a couple of examples of inevitable abortion already in my testimony. And premature rupture of membranes. And as it turns out, I've also given that example as well. And may include some other medical conditions such as diabetes and multiple sclerosis. It does not include a condition related to one's mental health. And I would further add that the law's wording is explicitly about intrauterine pregnancies. So it eliminates the possibility of confusion about ectopic pregnancy. Clearly treating an ectopic pregnancy is permitted by the law.
So in your opinion, does the Heartbeat Act satisfy the requirements of the principles of medical principalism as you described them today?
Yes, I believe it does.
Thank you. There were no further questions. Good morning, Dr. Sullivan.
Good morning to you.
Can you hear me all right?
Yes, I can. Thank you.
Now, Dr. Sullivan, you were not an obstetrician and gynecologist, correct? And sometimes we refer to obstetricians and gynecologists as OB/GYN, is that right?
Yeah, that's okay.
So I may use that throughout my examination. Now, you don't hold any board certifications related to obstetrics, correct?
Thank you, Doc.
And you don't have any formal training in obstetrics, is that right?
No formal training, no.
And you have not cared for the pregnancies of pregnant women in the United States, is that correct?
No, I've not specifically provided pregnancy-related care in the United States. No.
Thank you, doctor. And as a surgeon in the United States, when you were practicing surgery, any medical care that you provided to pregnant women was not in the nature of obstetrics. In other words, it was not related to the pregnancy of these women. Is that correct?
With a few exceptions, that is correct. There was one case where I had a woman who was in her second trimester of pregnancy who had appendicitis. And so I worked with an obstetrician to maintain, to help making sure that the pregnancy is maintained. When I operated on her to remove her appendix, so that we could preclude the possibility that she would go into labor. So I worked closely with an obstetrician on that.
while you were focusing on appendectomy.
Yes, ma'am.
And so as was clear on direct examination, you're not holding yourself out here as an expert in obstetrics and gynecology in this case in any way,
I'm
correct?
not speaking as an expert in obstetrics today.
And you have never performed an abortion with the intent to terminate a pregnancy, is that right?
I've never done one procedure.
And you don't have any postgraduate training directly relating to the clinical practice of abortion.
I do not.
And you have never observed an abortion being performed,
No, no.
and you're not holding yourself out here today as an expert on abortion care.
I am not.
Now, you retired from the practice of medicine in 2020, is that right?
Yes,
So you no longer have an active Ohio license to practice medicine,
that's correct. I'm considered retired.
and you're not currently providing any clinical medical care to patients, is that
I
right?
am not currently taking care of patients.
So, I mean, suffice it to say, the expert opinions that you're offering in this case are limited solely to medical ethics.
That's accurate.
So let's take a look at your report. I believe it was marked Defendant's Exhibit H. But I also heard Exhibit B, so I just want to make sure I got that exhibit correct. Do you have that in front of you?
Just, and I see the page, so I can keep up with you.
And that is your expert report. We also have that on his plan Exhibit 5. Which you could display. Would you want to like binder? Would you want to like binder? Would you like a binder? You have.
I have a report. Thank you.
All right, so, with regard to paragraph 22, I'd like to confirm that with regard to the statements made in paragraph 22 by you, Dr. Sullivan, you're not holding yourself out as an expert on the topic of the safety of abortion as compared to carrying a pregnancy to term. Is that right?
That's correct. I'm not an expert on this.
And let me direct your attention to paragraphs 23 and 24 of your expert report. You're also not holding yourself out as an expert here today on the topic of mental health outcomes as related to abortion care, correct?
That's correct, although these kinds of understandings weigh in on bioethical deliberations about them. So what we learn from other experts does inform our understanding of the ethical opinions.
To be clear, you're not here today as an expert on mental health outcomes as related to abortion care.
That is correct.
And looking at paragraph 25 and the statements made in that paragraph of your report, you're also not holding yourself out as an expert on the topic of suicide related to pregnancy and pregnancy termination. Is that correct?
No, I'm not.
And then you're also, Dr. Sullivan, not opining here today on the clarity of the legal language of SB 23.
Since I'm not a physician practicing under those limitations, I can't comment on how clear the language is for a practicing physician.
And you're not a legal scholar.
I am not a legal scholar.
All right, let's talk a little bit about paragraph 7 of your report. So
It is your opinion, Dr. Sullivan, that abortion is not within the realm of healthcare because it is, quote, not designed to cure a disease. Is that right?
That is my opinion.
But you agree, Dr. Sullivan, that not all healthcare is designed to cure disease, right?
It's true.
So, for example, you agree that diagnostic procedures qualify as healthcare, right?
It certainly do.
And that not all diagnostic procedures are designed to cure disease, right?
That's correct.
And would you also agree that healthcare includes preventive care?
Yes, I do.
And would you also agree that preventive care is not designed in all instances to cure disease?
Oh, that's true.
So then, in fact, you would agree that healthcare is not confined only to procedures or interventions designed to cure disease. Is that right?
No, that's nothing I'm confined with. Confined healthcare.
All right, so let me move on to the medical ethics area. And you testified on direct examination that it is your opinion that the fetus should be accorded moral regard. Is that right?
Yes,
And is this at all stages of pregnancy? That,
Yes.
that your opinion upon? But medical ethicists disagree in fact about whether or not to accord the fetus moral status. Isn't that right?
that's accurate.
And in fact, isn't it true that there's a lot of disagreement amongst medical ethicists about whether to accord the fetus moral status?
Yes,
Yet, it is your position that your opinion should be imposed on all pregnant women, regardless of the pregnant woman's own view of the moral status of the fetus. Is that correct?
that is my opinion.
And that it should be imposed on all other physicians who are faced with treating pregnant women. Is that correct?
I believe that we should accord moral status to the unborn. And that abortion, induced abortion, that is not necessary to save a woman's life or major bodily systems should not be performed
By any physician,
by physicians.
regardless of the physician or the pregnant woman's own view of the moral status of the fetus. Is that right?
That is correct.
Now, you testified that you're not practicing medicine currently, right?
That's correct.
And you are not and have never provided abortions, correct?
That's correct.
And so you are not being faced with patients coming to you seeking abortion, correct?
I have counseled women who have been interested in having an abortion. So I have been faced with that circumstance and that I have been asked to give input to them.
Thank you, sir. My question was in the present day. You are not facing patients.
I'm sorry, I misunderstood your question.
That's okay. You are not seeing patients
I'm
currently.
not currently in that kind of position. No, you're right.
And so you are not having currently to make medical judgments and medical decisions about whether abortion is permissible in any given situation under SB 20. Is that right?
I'm not facing that particular dilemma.
And now we can talk about the facts a little bit. So throughout your medical career, you have never been in a position where you could face criminal prosecution for the exercise of your medical judgment. If a prosecutor was to disagree with your judgment later on, is that right?
I've not ever been in that position, no.
Dr. Sullivan, you were affiliated with the Ohio Right to Life organization for 6 years, is that true?
That's correct.
From 2007 to 2012, is that right?
It sounds like it.
And you're also affiliated with the Christian Medical and Dental Association.
I am indeed.
And Dr. Sullivan, your Christian faith is part of your identity as a professional, is it not?
It is.
Now, you agree that providing comprehensive sex education could reduce the number of abortions?
I think that's an accurate statement.
And you agree that providing access to contraception could also reduce the number?
I think that's a good idea. Yes,
So you support contraception?
I do.
let's see that if in accordance with your prior testimony, the zygote has no status to be in accord with medical ethics, what forms of contraception would need to be outlined?
I don't know that
None.
I've written about this subject in detail. And there are some types of contraceptives that people, if you're allowed to say, in the pro-life community, have been concerned about. But I've written on these subjects rather extensively and do not feel that that concern is justifiable, inasmuch as there is no interceptive mechanism to find an interceptive mechanism wherein taking those hormonal agents would interfere with the trajectory of human embryo for implantation in uterus. So I do not feel that contraception, broadly understood, is at odds with the testimony I provided here.
All right, thank you, Dr. Solomon. I have nothing further at this time.
You read it.
So Dr. Sullivan, just for clarity, you were asked about paragraph 22, 23, 24, 25, and as to whether you were expert on those subjects. And you testified that you're not. Why do you discuss those topics then in your expert report?
Because bioethical reflection requires the reliance on other experts. When I'm consulted in a difficult case as an ethicist, I do it by interviewing all of the family, by interviewing the physicians that are caring for the patient, and I rely on their judgment and determination of the facts of the case. And then I put that all together. So of course, I'm going to quote literature from psychiatry, I'm going to quote literature from obstetrics, I'm going to quote literature from the broader discussions that we're having today about abortion and its aftermath. I can deliberate and render opinions relative to those subjects without specifically being an expert in obstetrics, psychiatry, or other areas that have been mentioned.
So it just informs the weighing and balancing of your decision?
It's a difficult weighing and balancing. That's why it's not a simple formula. We have to weigh these things to achieve clarity in ethics. When we deliberate in the ethics committee, we're doing that weighing and balancing, and it becomes very clear to all the members of that committee that one thing that is the right answer. There's a great deal of unanimity there in these deliberations, but it relies on having all facts.
And regarding paragraph 7 of your report, you say that you do not consider abortion health care. And when faced with the question of preventative care and early examinations, you agreed that was health care. So why don't you determine that abortion is the same as those types of health care?
Because deliberate induced abortion is an invasive procedure that separates one moral agent from another. And there's no disease that's being treated there in that circumstance, unless there are other overbalancing medical concerns going on, such as we've discussed today. So it does not fit under the purview of a healthcare procedure that we ought to be doing. And I believe that the state of Ohio has a rational basis for limitations on that procedure, which the High Board of Medicine, High Board of Pharmacy, put parameters and limitations on practice medicine all the time. So it's reasonable for us to limit procedures until, because another moral agent is involved to those that are absolutely necessary to preserve the life or the health of another.
And you testified that you believe that your opinion is correct, but are you here today to improve your opinion on all positions?
By no means. I recognize that there is debate about moral status. I would contend that there should be no debate about the humanity of an embryo, because I think that's given to us by science and embryology. But I understand that there is a debate about moral status of an embryo.
Thank you very much. No further questions.
Anything for us?
No, Your Honor, thank you.
Doctor, the court has just a couple of questions. Touched on some things that didn't sound upon. I want to make sure our record is clear. So I may jump around this. First of all, I think you said when you were explaining the conflicts of biomedical evidence in non-adolescents, fetal life, or in this case, embryonic, correct?
Yes, we're still in embryo. It's 6 weeks period of time. Yes, Your Honor.
Your system, according to any moral standing, that's the right word. The title, the embryo, and
I think that the unborn entity from the moment of fertilization and on forward should be according to moral status. Your Honor.
and if you said there's agreement about this, I think the kind of the one playing in summer, if you're a student out, you need to be there the chance to respond.
Once again, Your Honor, I would simply want us to be clear on the terms of the discussion. If I may simply state that the common way of putting this in our society, when does human life begin? And I think that that is conflating and confounding terms, because it's clear to me, as a scientist, as a physician, as someone who's taught the subjects for many years, that human life begins at fertilization, which we broadly call conception. There's some technical details there, but using the term conception. And I think that is a clear point. The debate then comes down to is this entity in the womb, is this the kind of human life that we wish to give the moral status to, which we wish to offer moral protection to? And so if I may want to simply explain that I think that's where some of our debates have come about.
That's fine. I think the characterization is going to hear from, as I understand it, the leading national biomedical emphasis to play a role in formulating policy for the predominantly accepted professional organizations, the American medical system, etc. These kind of things. I believe you are going to be very use the term directly appointed as an extreme ally in this field. And I want you to respond to that. We have the appropriate work on the opportunity to for those listening to have the benefit of understanding how you respond or whether you disagree with it, or whether you're self-aware enough to acknowledge it. Go ahead.
Yeah, it's a fair question. First of all, I'm a member of the American Medical Association that is physician needs to be a part of the 30% of all physicians, and they do not represent my view, which is about a number of my colleagues in the medical profession. Furthermore, I'm not a member of ACOG, American College of Gynecology, but there are many obstetricians that are a member of college and board certified by the American Board of Gynecology who do not agree with those opinions. So those may be the opinions of professional organizations, but there are many people in the practice of medicine and in bioethics, especially generally, that would look at these concepts in the same way I do.
A couple of other things. And I think you focus in your testimony in your report on the side of the equation, you was something of non-adolescents to feel. But I think what this court is constitutionally obligated to focus on is the rights of a citizen, a woman. And as far as this court is concerned, they should be awarded equals. That's what our Constitution says. But it sounds like you're okay with limiting their autonomy to use the term. Because a woman is forced to carry pregnancy that she doesn't want to carry with her. I don't think you could, with a straight face, disagree that you're limiting her autonomy. You're restricting her opportunities. You're restricting her rights. You're relegating her to a different status than those of us who cannot be pregnant. They're not subject to the requirements that carry with her. So I just want to understand, I want you to put on the record why your judgment on that is superior. Why, what endows you with the ability to make that judgment in a way that's better than the individual citizen who writes this court to determine, or it's not you. What endows others in the legislators with the right to protect judgment. That's really what we're talking about here today. Is until recently, women have the right to choose under our federal constitution. The question for this court is whether they have the right to choose under the state constitution. You're here today telling this court they should, under this law is okay. And it's okay from an ethical standpoint. Because you think it's okay. My question is, what endows you uniquely? Make that judgment better. Whose rights we are women. Whose autonomy really has to take away. That's really what I want to be.
Thank you, Your Honor. Very clear from my broad experience with bioethics that we place limits on a woman's autonomy all the time. So if a woman comes in with who is delirious because she has ketoacidosis with complication of type 1 diabetes, she has a high sugar level, so she's out of her head, and she's the people in the emergency room trying to put in an IV, and she's saying, no, leave me alone. I don't want anything. And the husband says, take care of her, and hold her down and force her and give her the treatment. Afterwards, she says, thank you. So it's clear that there are indications, and that's an extreme example. They're clear that there are indications where autonomy is not absolute. State of Ohio, the number of instances that put parameters on autonomy. We recognize in Ohio no right to euthanasia or assisted suicide in this state. That is a limitation both on individuals and on medical practitioners. So the idea that we might infringe on autonomy per se is clearly not a violation of medical practice because we put limitations on women's autonomy all the time. So it's based on a value judgment where the state, as the federal legislature is done, I'm not a legal scholar, but have said that the unborn need consideration, need to have that considered. And if they do, therefore, bioethics and prevention of harm to the unborn. That way, balancing does take place. And yes, there are limitations on the woman's autonomy thereof. So I in no way feel that that is an extreme position. That is one based on my long understanding of medical ethics and practice.
Your testimony is no way based on by a Christian faith.
My Christian faith is a part of my life, Your Honor. But as I try to to objectively look at these issues. I recognize in our broader debates that religious and philosophical considerations should be part of the broader discourse. Having said that, I have no way intend to privilege my personal religious faith in this manner, because that's the way I've practiced medical ethics since I became an ethicist. I have always tried to use the secular pluralistic framework of medical principles to reach judgments that afford the most beneficence and the most non-violence to the greatest number.
Couple of specific questions. But one thing that I don't think either council supported is the absence of intervention for people in comments. I don't think this would you agree that the bill is deficient, not for procedures in the case of extreme serious fetal anomalies of fetuses, little chance of survival. I think it's very short. Very, very, very challenging. But it seems to be this board of the worst deficiencies. You're here as the advocate for the ethical decision in the United States. So that will be somewhere.
Either in cases of severe fetal abnormalities, I'm not a legal scholar, so I'm not sure how to craft the law really does that. But once again, a disabled child, disabled baby, we have so many helps available to us in our society, simply to eliminate life because of those abnormalities. Once again, we're here to violate the principles that I tried to advocate in the testimony. So there's nothing easy about those circumstances, Your Honor. I recognize that this can be agonizing for a woman. Any type of defect or disease is horrible for the person that has to go through it. I am not without sympathy for that difficult circumstance. It is simply, I'm not a legal scholar, but I don't know how we would craft a law that would specify certain conditions that could be exceptions to the bill. And so therefore, I feel like, as stated, I think that the law as currently written is well reflective of violent persons.
Did you hear the testimony earlier of Dr. Horn about the year?
No, Your Honor, I was not.
You did not hear the case that she observed firsthand of a woman who's the fetus she was carrying had no lower extremities and the organs were developing outside of the body and had little chance to survive. But you didn't hear that case.
No, Your Honor, it sounds tragic.
But just as people look at the state's medical emphasis is okay with requiring the use of these in accordance with biomedical ethical principles to require a woman to carry at the assumed term to deliver it outside C-section versus herself, knowing that the fetus is going to die. No, that's never in the state's view. Because that's what this law requires.
Your Honor, so I'm not an obstetrician, so I'm not able nor willing to comment on a specific case. The kind of case you present sounds very difficult.
Appreciate that. Last question. Paragraph 26 of your report was somewhat challenging to the court. This paragraph deals with the issue of victims of rape. I understand in your report that your system of biomedical ethics places the rape victims autonomy below the principle of non-molestation. But still that correctly, I just want to be sure I understand. Is that again? In this court. Seems like a failure of this section. But
Your Honor, first of all, I have two comments that I'd like to make. If I may.
sure.
Your Honor, first of all, that's a horrible crime. I'm not in law enforcement, nor am I a legal scholar, but rape is a horrible assault on a woman. It will cause her to suffer greatly for the rest of his life. However, with regard to non-licensed to the fetus, that unborn fetus is innocent of that violence. Therefore, it's not subject to additional prejudice, or otherwise would we change the standard approach if we have an approach to medical ethics honors the value of the fetus, then it would be irrespective of how the pregnancy occurred, as difficult as that circumstance might be. Your Honor, my second comment is that I know of no report in my review of the literature that shows that women who have had an abortion have better mental health outcomes as a result. And so therefore, an overall commitment to women's health, it seems to me that claim is once again vague and doesn't really look at what available evidence there is. Some
All right, does anyone should have any follow-up questions to Dr. Gates, but I'm going to say the court asks to well, the school of us now. So anyone have anything else for Dr.? All right, thank you very much.
Thank you.
We're be able to take a break for lunch now at this time. I think it's 12:30. And our next witness will be able to appear until 1:30. So I thought that was about the appropriate time to ask them for that.
Good one. Good one. Let's recess until 12:30. I would ask that we assemble and try to be on time to start early at 12:30. Remember, we are included today. All right, very nice.
Reporting back in, make them order this thing.
I'm ready to proceed.
Robert, we've got one small update before we just given the testimony this morning, in the interest of time, the state defense been no longer calling Dr. Bowles as a witness.
And Your Honor, your name, we understand from our conversation with the other side that they're actually not just not calling, but they're withdrawing his expert report. I just like that confirmed. Correct?
Your Honor, we would simply want to not call him as a witness, but if the position is that if we don't call him a witness, then we have to withdraw his report, or else he can be prosecuted, then we would agree to withdraw his expert report. But we would just request not call him as a witness.
And we would just say that if they're not going to call him, we'd like to cross-examine him. If they don't want to cross-examine him, then his testimony should be.
Well, I think you took a full position.
We did, Your Honor.
Say that we're not calling in this case, the chief of the wants to present the report. Yeah.
No, Your Honor. There are many other topics I would have cross-examined him on beyond the deposition. The state insisted on terminating the deposition after 3 hours before my examination was complete. I had a number of other topics I would have crossed.
Your Honor, so on that point, the parties obviously have disagreement on that, but it's the state defense position that all expert witnesses be abided by this for when you hour
That's what the parties had.
No, it was their position. It's not an agreement.
Respectfully, Your Honor, it was, and we believe the email exchange between the parties reflects that.
Well, we asked them to point us to those exchanges and they never did, Your Honor. So
We're going to resolve that disagreement. The state is the witness available. What was here, but that's
He was going to testify myself.
I don't know if you want to, I wouldn't understand the rationale.
Just given the fact that the state defense don't have the burden in line with the testimony this morning, and in the interest of time.
The role's expertise was what exactly, so that we understand what you're talking about.
So he is an expert in obstetrics and gynecology.
And you don't really need his testimony because testimony already said exactly what it's already.
Yes, sir.
I think if you're not subject Dr. Bowles to full cross-examination, then you can't have it both ways. The court believes that plaintiffs, since they're very burdened at the preliminary judgment stage to make their show, have a right to present all the evidence that they want to present, including the opportunity to cross-examine anything that you want the court to consider. Otherwise, this would just not be fair. So if you want the court to consider Dr. Bowles' expert work, which would be fair too, the Dr. Bowles needs to be available across. So you want to get Dr. Bowles available to call and sit on cross. So claim sacrifice opportunity. That's fine. We will consider the report in that instance. That's really your call. you don't want to cut the most available on that basis, then the report won't be received.
Then Your Honor, we would go for the latter position.
All right, those reports is gone, won't be considered by the report. Good. Okay. Good question. Why is there a chair?
Oh, you know, I had a number of binders that I was gonna need for Dr. Bowles's exam, but because he's not being called, I can remove the chair.
All right. Maybe you want to do that.
I got it.
Probably another participation on the empty chair. They had another case. So, all right. All right, what's next?
So next, Your Honor, we will be presenting the direct testimony of Dr. Parker.
Very good. Great.
Thank you very much. Just read the testimony, give his cause will be the truth, the whole truth, and nothing but the truth, so help me God.
Afternoon, Dr. Parker. Could you introduce yourself to the court, please?
I'm Dr. Michael Parker. OBGYN from Columbus, Ohio.
And could you please spell your name for the court?
Michael, M-I-C-H-A-L, Parker, P-A-R-K-E-R.
And are you a medical doctor?
Yes,
Dr. Parker, the state has asked you to provide testimony here today regarding the Human Rights and Heartbeat Protection Act, which I will refer to as the Heartbeat Act for short. Are you familiar with the act?
yes,
Are you prepared to testify regarding your expert opinion in this case here today?
yes.
Before we get to your opinion, Dr. Parker, can you tell the court about your educational background?
I'm a graduate of Kenyon College with a BA in biology in 1985. Completed my medical degree at the Ohio State University College of Medicine in 1989. I stayed at the Ohio State University to complete my residency training, which completed in 1993.
And what work have you done since completing?
I was in private practice, GYN from 1993 until 2015. From 2015 until the end of 2018, I was an obstetric hospitalist at the Cleveland Clinic. And since 2019, I've been working as obstetric hospitalist for the Mount Carmel Health System in Columbus, Ohio. In that capacity, what I was doing, I served as the chairman of the hospital BGYN division. I Grant Medical Center for several years. I've served on peer review committees and quality improvement committees during my time with those in that capacity. My main focus of my medical practice was treating infertility and endometriosis during laparoscopic surgery towards the end of my career, and then currently I'm focused on just the delivery of obstetrical health care on the hospital setting.
So just to confirm, what would you say your specialty or specialties are?
Obstetrics and gynecology.
And just to be clear, how long has that been your area of expertise?
Since finishing residency in 1993.
Do you have any medical certifications?
Well, I'm board certified by the American Board of Obstetrics and Gynecology. I renew certifications for electronic fetal monitoring on an every 3-year basis. I'm required to, I had certifications in obstetrical hemorrhage, hypertensive management during pregnancy, management of shoulder dystocia and other obstetrical emergencies periodically throughout. My training is we're required to recertify on those on a periodic basis as part of our credentials for the medical staff.
And at this time, I would like to tender Dr. Parker's expert report, which is marked as defendants, exhibit I. Dr. Parker, what is the document that I just handed you?
This is my report that I made with regarding the case expert report.
And is this a true and accurate copy?
I believe it to be so. Did you also give me this?
That was my next question. So I believe attached to your report as exhibit I is your copy of your CV. Could you let me know if that is a true and accurate copy of your curriculum item?
Yeah, it's what I presented, yes.
This time, state defendants moved to admit into evidence Dr. Parker's report and CV.
No objection.
So, Dr. Parker, have you reviewed any current literature in preparation for your testimony in this case?
Yes.
And what literature have you reviewed?
I reviewed several ACOG articles on preterm labor. I looked up some articles regarding safety of abortion. I wanted to refresh my memory on the stages of grief, and so I looked at that. I wanted to look at some legal terms that were in the that I needed to understand. So I referenced online law dictionary. Trying to just refresh my memory here. Down on this. I looked at some statistics from the Guttmacher Institute and the CDC with regards to treatment of breast cancer, and another review article on treatment of gynecologic cancers in pregnancy, or cancers in pregnancy. Those are just, that's right, I remember this time.
And just for the record, you mentioned ACOG earlier. Could you just tell the court again what that is? Just remind us.
It's the American College of Obstetrics and Gynecology.
Thank you. This time, Your Honor, we would tender Dr. Parker as an expert on obstetrics and gynecology.
No objection.
Dr. Parker, did the state's defendants provide you with any documents to review in this case?
Yes.
What were some of those documents?
They presented me with a copy of the Act, the Heartbeat Act, as well as some definitions regarding the Act in regards to abortion in the state of Ohio. They provided me with a copy of the plaintiff's complaint and the affidavits that were filed in support of the complaint. And I believe there were 2 copies of the complaint. I'm not sure legally what those were, but I both received.
And Dr. Parker, you mentioned some of the literature that you reviewed earlier. When you were drafting the report, how did you choose what to review?
Well, I was given a very short time period to review a lot of things. I was asked to do this, and I was told I had to be ready by the following Wednesday, and this was on a Thursday. And so I chose to be a little bit selective in what I reviewed to see where things stood. The plaintiffs have made the statement that abortion was safe. So I wanted to review is the data that they're using accurate, and can I rely on the data that they're using to make that statement. I looked at it, so I looked at that. I looked at the statutes to see what certain things meant. So I reviewed definitions that were given to me for some of the things within the statute. I wanted to refresh my memory on, again, in some of the affidavits, they mentioned how the women were reacting to finding out they could not have an abortion. And so I made I wanted to review what the grief process was and how that would play in here, because that's what I felt they may be experiencing at the time. I also wanted to review briefly just some of the diagnoses that they had mentioned as complications that women were experiencing and why they were presenting for abortion that were mentioned in the affidavits. One of those was with rupture of membranes at 13 weeks from a procedure. So I wanted to look at that, but it was not part of my report. And then a woman with melanoma that was also mentioned in there to see how melanoma would play into that. And then somebody else who presented with a cancer. And so that was generally how I went about it. I wanted to kind of look at those things.
And Dr. Parker, what opinions are expressed in your actual report?
Well, I was asked by the state to review the act to see if me, as a general Joanne working in the community, not in academic medicine, what was my understanding of the act? Could I understand it fairly clearly? I remember in the plaintiff's complaint, they thought that the statute was vague. And so I wanted to look at that and see what that. So I was asked to do that. And I found that I can understand the statute and what's required from me. I may not understand all the legalese of what's going on, but if I read the statute, I can understand what I can and cannot do as an OBGYN in that statute. New statutes that come out, especially with regards to abortion, the uncertainty about what they mean is not uncommon. We saw that with the enactment of the 20-week Abortion Act here in the state of Ohio. And so, I wanted to, that was one of the things that was brought up, is that the uncertainty of what this means. And in my, it has appropriate requirements, and I thought that the act could be easily understood by a physician who reads it and comes to understanding. My understanding was that this only applied to uterine pregnancies; it did not apply to ectopic pregnancies. And I thought that the requirements were clear and easy to understand, and that some of the portions of the act were already in acts that were in place in Ohio that doctors had been working under at that time. There was a thought that the exceptions to the act were limiting, but I thought they were open-ended and not vague. And as a physician, I felt that was appropriate, that they were more open-ended, because I wouldn't want my decision-making process to be hindered by legislators. I'd like to use my reasonable medical judgment to make decisions about handling those situations. I don't think it would be hard to understand the act if another physician read it. I think if many of my colleagues are represented to, they might take some of the same conclusions that I did. You can treat miscarriages. That was a misunderstanding that had been going around in my community. The act clearly says that you can do that. And I felt that many of the other, just to kind of finish up, the conditions that many of the exceptions include, which is preeclampsia and diabetes, it may include multiple sclerosis, premature rupture of the membranes, and inevitable abortion. Many of those complications are occurring much later in pregnancy, and they can be managed medically.
So, Dr. Parker, just on what you just said, you mentioned a couple of these, but I'll just go through them more specifically. So, in your expert opinion, can diabetes in a pregnant woman be treated without an abortion?
Yes.
Can hypertension in a pregnant woman be treated without an abortion?
Yes.
In your expert opinion, can autoimmune disorders in a pregnant woman be treated without an abortion?
Yes.
And can a heart disease in a pregnant woman be treated without abortion?
Yes.
As to renal disease, in your expert opinion, can that be treated without abortion?
Yes.
Have you ever seen in your time as an expert in obstetrics and in practice, have you ever seen a case or encountered a situation where a pregnant woman's life was at risk unless she was have an abortion?
Excuse me. Have I ever had, your question is, have I ever had an experience where a woman's life was in danger and she needed to have an abortion?
Correct.
I've not had an encounter where I've had one encounter where we were faced with needing to deliver a baby who still had a heartbeat in a very critical situation. By the time we got to the operating room, the heartbeat was gone for the baby. The mother was being stabilized, and so it would not have been considered an abortion in this situation. So, in that respect, no, I have not. It was near. It was very near that, but no, I have not.
And have you encountered in your practice a case where a pregnant woman is at serious risk of a substantial and irreversible impairment of a major bodily function unless she has an abortion?
To my recollection, I've never cared for a woman who was at risk for severe and irreversible impairment and needed an abortion.
And Dr. Parker, if a physician reasonably concludes, or in their his or her reasonable medical judgment concludes that a particular patient needs an abortion to save her life, can the doctor perform the abortion without violating the Preterm Act?
If in a reasonable medical opinion, yes. And if they to the other requirements of the act that are involved as far as the documentation.
And if a physician in his or her reasonable medical judgment concludes that a particular patient needs an abortion to prevent serious risk of a substantial and irreversible impairment of a major bodily function, can the physician perform the abortion without violating the Heartbeat Act?
Yes.
Dr. Parker, are women with underlying medical conditions at a higher risk of any complications during abortion procedures?
It depends on the gestational age at which time the abortion is being performed, and whether there's a need for general anesthetic or it's farther along gestation age.
Can you elaborate on that a bit more?
Sure. If, for example, there was a case that was on CNN News lately that discussed a woman here in Ohio who had found out that her baby at 22 weeks had lack of immunity requirement multiple anomalies. This woman also had clotting disorder, autoimmune disease. I'm not exactly sure what those were. And that woman at 22 weeks they commented in the article that she was high risk for blood clots and bleeding. And she was, if you're going to perform an abortion at 22 weeks gestation, I don't know how they would have, what procedure they chose to do this. She had a lot of stage to receive it, but if you were refusing abortion, if it was a D&E or a type of procedure that would place the woman at greater risk for bleeding and blood clots associated with her autoimmune disorders, and she had and depending on what medication she was on, some of those medications could affect the outcome of the surgery if surgery was chosen.
In your opinion, Dr. Parker, can complications related to abortion occur?
Yes.
And what are some of those potential complications?
Bleeding, infection, perforation of the uterus with damage to other internal organs such as the bowel or the bladder, adjacent structures such as the fallopian tubes, the ovary, lacerations of the cervix, death can occur from surgery.
For those first, obviously, other than the last one you mentioned being death, for those other complications, what are some of the impacts of those complications on the woman?
Well, if she's bleeding, it depends on the amount of bleeding that she's having and when it occurs. Many times, or not many times, but there are times when women are presented to the emergency with bleeding afterwards. And the bleeding can be heavy to where they become and they require blood transfusion. If it's very severe, it could actually cause them to not be able to clot their own blood, and so they just continue to bleed. With infection, if they develop infection afterwards, it's possible that it could result in damage to the fallopian tubes and result in impairment of fertility later. It's typically confined to the endometrium of the lining of the uterus, but it may require to be hospitalized for antibiotic therapy, and can result in scarring in the trigeminal cavity. With regards to uterine perforation and injury to the bowel or the bladder or to other organs, it may require a more extensive surgery such as a laparotomy to repair the damage to the bladder or the bowel or even the bowel resection, and either it may need removal of some of the other organs.
Dr. Parker, in your expert opinion, does the risk of death that you mentioned earlier in patients with underlying medical conditions remain if a woman chooses to have an abortion?
The risks that are present with a woman who either remains pregnant and or has an abortion, they're still very similar risks. Should a woman, and if we look at those risks that would be comparable, yes, they're still there. So if a woman has to have a surgical abortion, or if she has a cesarean section for her delivery, then a lot of those risks will remain, and some of those risks will remain with the vaginal. So yes, they do still remain.
Dr. Parker, do you have an opinion on whether complications from abortion are underreported?
Well, that's one of the things that I really wanted to look at. And what we know from the Guttmacher Institute and from some of the articles that I read was that there is an underreporting. Only a quarter of states are required to report deaths related to abortion. Only about 28 states report complications from abortion to the CDC, and all the reporting is voluntary. And some of the states that don't report are some of the largest states, such as Texas and Virginia, Massachusetts, that don't report their statistics on complications to the CDC. It's also difficult to get data because many times the women who may be having complications are not being seen by the facility where she had the termination of the pregnancy, or being seen by the doctor who performed the termination of the pregnancy. So, and those doctors, for whatever reason, may be hesitant to report those cases, or may not even know what was going on or why the person was there. If they did experience a death, they may not know that the woman had recently had an abortion, or the family might not know that the woman had an abortion because she didn't tell the family for whatever reason. And there may be some hesitancy to put that on there. So there are a lot of areas where the accuracy of the safety that could be called into question, not a statistic, not a person who can statistics, but we don't, there are large holes in the data that are there. Yeah, so.
Dr. Parker, in your expert opinion, when do conditions of preterm labor occur in terms of gestation?
By the definition of preterm labor, it doesn't occur until after 20 weeks of gestation.
And in your expert opinion, when do conditions of preeclampsia occur in terms of weeks of gestation?
Again, by definition, it's after 20 weeks of gestation.
And in your expert opinion, Dr. Parker, when do conditions of gestational diabetes occur in terms of gestation?
Gestational diabetes may be diagnosed later in some women because we don't routinely test for gestational diabetes until 24 to 28 weeks. Some women who are at higher risk for developing diabetes can be tested for diabetes earlier in their pregnancy in the first trimester. If they're found to be positive, then they can be managed medically for that. The complications that occur with diabetes may not show, with gestational diabetes may not show up until later in pregnancy, such as around 32 to 34 weeks.
Dr. Parker, in your expert opinion, are the exceptions in the Heartbeat Act sufficient to allow for the proper care of pregnant patients?
Yes.
And could you expound on that a bit more? Why do you think that's the case?
Well, the exceptions are there. The difficulty that I have with the acceptance of my case, as I just stated, many of these conditions don't start until after 20 weeks. Most typically, mid to late second trimester, around 20 to 28 weeks, is where we may see cases of severe preeclampsia, complications from diabetes, heart disease, as the maternal body changes in the second trimester and onward. We start to see these complications later in pregnancy. The standard of care in those situations is not to do abortion. The standard of care is to deliver a baby. So, example, if I have a woman who has preeclampsia at 24 weeks gestation age, and that preeclampsia is getting worse to the point where we have to balance the condition of the mother versus the premature delivery of the baby. Yes, under the statute, she could request to have an abortion performed. Most doctors would do a delivery, either attempt to do a vaginal delivery or a cesarean section at that time. And under the current Ohio law, at 20 weeks, what would need to be done, an abortion could be done after 20 weeks if in the 20 weeks, they have to provide a procedure that gives the baby the best chance to survive. And that would be their attempt at vaginal delivery, unless they felt that it was that procedure put greater risk to the mother's life, at which time they could perform an abortion procedure.
Thank you, Dr. Parker. No further questions.
Just on the moment I was going to be on TV,
He's better looking than me.
so I'm kidding, right? Thank you. Good afternoon, Dr. Parker, and good to see you. We met for the first time earlier this week at your deposition, correct? And am I correct, sir, that you yourself have very strong personal beliefs about abortion?
I do.
You've attended multiple national protests against abortion.
I've attended 5.
You've been the national president of an organization called the Catholic Medical Association, correct?
Proud.
And the Catholic Medical Association advocated for the overrule of Roe v. Wade, correct?
Yes.
And in fact, while you were the president of the Catholic Medical Association, you signed off on a brief that the Catholic Medical Association filed in the Supreme Court of the United States asking that Roe v. Wade be overturned, correct?
That's correct.
Since completing your resume, you have never yourself performed an abortion?
I've assisted but not performed.
Since completing your residency?
Not since completing my residency. I'm sorry, I misunderstood the question. Thank you.
So in the last 29 years, you have neither performed nor assisted in abortion?
No.
And for reasons of personal conscience, you chose in your private practice not even to dispense birth control, correct?
That's correct.
You serve as the medical advisor and a board member of something called the Women's Care Center of Columbus, correct? That's what's known as a crisis pregnancy center.
Yes.
And the Women's Care Center in Columbus chose to open its facility across the street from the largest abortion clinic in the region, correct?
I believe that to be true.
And the Women's Care Center tells women that there's an increased risk of breast cancer associated with abortion, correct?
Incorrect. I spoke wrongly and I put that in my errata sheet to my deposition. They do not provide a statement that abortion causes breast cancer.
Sir, you put in a errata sheet that said they didn't say it caused breast cancer. But I asked you the question of whether they told women there was an increased risk associated with abortion, and you didn't put in an errata sheet with regard to that testimony.
Okay, and I misunderstood that, but I have clarified that they do not provide that information.
But you agree, sir, that the Women's Care Center measures its success based on the number of women who visited it and decided not to get an abortion, correct?
That's correct.
And you used to be a member of the American College of Obstetricians and Gynecologists, correct?
That's correct.
That's the nation's leading organization of obstetricians and gynecologists.
It's the largest.
And to this day, in your practice, you routinely rely on information provided by the American College on topics other than abortion, correct?
Yes.
But you resigned from the American College over the issue of abortion.
Yes.
And that when you resigned, you joined the American Association of Pro-Life Obstetricians and Gynecologists, correct?
For a brief period of time.
Your personal belief is that abortion should be unlawful in all circumstances except to save the life of the mother, correct?
I don't know that I've said that. I said that's somewhere I can go.
Well, is that your belief?
I believe abortion is wrong. It's not up to me to decide whether it's lawful or unlawful. That's up to the states.
Well, do you remember being asked this question at your deposition, giving this answer, sir? Question, this is at page 137. Do you believe that abortion should always be unlawful at any point after fertilization? Answer, my personal beliefs, my faith allow me to say, yes, I do. Remember giving that answer?
Then yes, I do.
You believe that even in the case of rape or incest? Right?
Yes.
You testified in the Ohio legislature about the legislation that's been issued in this case, correct?
Yes.
You testified in favor of that legislation, right?
Yes.
And now you're here being paid by the state to support that law.
Yes.
You offered some testimony on direct examination about the safety of abortion and as compared to childbirth, right?
Yes.
Okay. But you yourself have not actually read the 200-page report the National Academy of Sciences put out.
At the time of the deposition, no.
Did you read it after the deposition?
I skimmed through the 200 pages, yes.
Okay, but you haven't read the full report.
Well, a lot of the report is reference and empty pages. The 200 pages that are there, they have summaries of the areas, but a lot of the 200 pages is references and empty pages.
Well, can you answer my questions?
I haven't read the whole thing, the time district.
Well, you offered your opinion in your report before you had actually been read, the National Academy of Sciences had to say on the subject, right?
That's because you'd already presented in the affidavits and in the plaintiffs that it was safe, and you had referenced that. I believe you had referenced it in there. And so I went to look, was that data accurate? And that's what I just testified to.
And the data that's, sir, when you prepared your report in this case,
Yes.
okay, the time you prepared your report and expressed your opinions on the safety issue, you did that before looking at what the National Academy of Sciences had to say on the topic, correct?
Yes, I did.
Now, let's talk a little bit about what the Heartbeat Act does and whether a regular doctor can understand how to conform with it. Would you agree with me, sir, that to understand the Heartbeat Act, one thing you have to understand is what is an abortion in Ohio law?
Yes.
And you offer some opinions in your report about what is an abortion, right?
There are some areas, yes, they are.
And let's take a look at paragraph 29 of the report. We'll put that up on the screen. That's Dr. Marcus Plaintiff's Exhibit 3. page 7. Let me know when you're there, sir.
I'm there.
So in paragraph 29 of your report, you're discussing a circumstance where a hysterectomy was necessary to remove the uterus of a pregnant patient with cancer, correct?
Yes.
And you discuss your view as to whether that procedure would be an abortion, right?
Correct.
And what you say in the second to last sentence of that paragraph is that this procedure does not constitute an abortion, right?
And that's my opinion.
Right. And then in your deposition, we actually looked at Ohio law. Remember that?
Yes, I remember.
And under Ohio law, that procedure does constitute an abortion, correct?
I'd like to be refreshed.
Sure. Sure, let's take a look. That would be exhibits, put up corporate across exhibit 5. Sir, am I correct? Across exhibit 5 is section 2919.11 of the Ohio Criminal Code defining what an abortion is. Right?
Yes, I can't see.
What do you have it in front of you?
No, no.
Oh, sir, I'm so sorry. Here I had all these nice binders and I didn't give you one. My apologies.
You're so kind.
Take a look at tab 5, sir, in that binder, if you would. Your Honor, I have a copy for you as well, if you'd like one. And sir, have you had a chance to look at that?
Yes.
And that is the definition of an abortion under Ohio law. You see that?
Yeah.
I mean, one of the things that we talked about in your deposition was that you had said in your report that the reason this hysterectomy was not an abortion was because there was no direct act taken to end the life of the fetus. Remember that in your report?
Yes. I remember.
But the statute when it defines abortion doesn't have a direct act requirement, right?
That's correct.
And you'd also talked about how in your report that the loss of the fetus was not intended. Remember?
Yes, I remember.
And of course, that is not what the statute says even, right?
No.
Right. So the statute doesn't say it's only an abortion if the loss of the fetus is intended, correct?
No.
Okay. And so actually, when you look at the statute, you can see that the reason that you gave for saying this procedure was not an abortion are not reasons that the Ohio statute recognizes for saying that something is not an abortion, correct?
I gave my opinion whether I thought it was an abortion or not. And that was based on my understanding of what you reported, what I thought an abortion was.
Right, but a doctor who had followed your beliefs about what an abortion was and concluded that a hysterectomy was not an abortion, and therefore they didn't need to worry about Part B Act, they go to jail, right?
I don't think there are many doctors that would argue with my interpretation of whether I thought that an abortion.
Yeah, that's right, but it's not what the law says, is it, sir?
No, it's not what the law says.
Okay. And you were writing in your report and you were talking about this. You said in paragraph 29, if you go back to that. You said in your report, the last sentence of that paragraph where you offered your opinion that this procedure was not an abortion. You said, well, no reasonable physician would consider him or herself barred by law from performing the procedure. You see that?
Yes, I do.
So you were trying to give your understanding of the law in that paragraph, right?
I would say that, in my opinion, I don't think a reasonable physician, by this statute, would prohibit from performing the procedure. Especially with regards to the fact that it may be intended to prevent a severe irreversible harm to the woman.
But sir, would you agree that sometimes the actual law doesn't match your opinion about it?
The way I read the statute, the way I looked at it from the perspective of providing my testimony on this is, I'm a general OBGYN working out there in the community, working with a large number of other OBGYNs who may be concerned about how this act affects them. And on a day-to-day basis, we're not always parsing the law or parsing the word means or whatever. We're acting what we think is a reasonable medical judgment for our patients to make sure that we are doing what we feel is in their best intentions at the time. So when I interpret this law and I look at it, and I say, I don't think a reasonable position would be barred from doing this under the law. I don't think they are. When we look at the fact that it may be to prevent irreversible harm to the woman. And two, I think if I took this to a number of my colleagues, whether they share my beliefs or not, many do not, they would see that this was an appropriate act.
Right, but you weren't saying just in paragraph 29, you thought it was an appropriate act. What you were saying in paragraph 29 was it wasn't an abortion at all, right?
I don't think it is.
Okay, but
In my, not according to the statute, the way it's written, you're correct.
Okay.
My opinion, I don't.
all right. So let's now take a look at the exceptions in the law, but let's look at the actual law, not just the opinions, okay, sir? And so if we could put up now exhibits Parker Cross 6, which is the actual Heartbeat Act. If you look at tab 6 in your books, you'll see this statute. And if you can turn to page 9, you know what you're.
What part do you
Take a look at page 9, section 2919.195. Yeah. Okay, and let's just talk about these two exceptions and whether they're easy to apply. Okay. The exceptions are in section B, right? Let me know when you see it.
That's correct.
Okay, and there's the exception for performing a procedure that in a physician's reasonable medical judgment is designed and intended to prevent the death of the pregnant woman. And then there's the exception to prevent a serious risk of a substantial or irreversible impairment of major bodily function. You see that?
Yes.
And we talked about in your deposition both of those exceptions and what their parameters were. Recall that?
I recall us talking about it, yes.
Yeah. And do you recall that we had an extended discussion on that life of the pregnant woman portion about how likely does death have to be for this exception to apply? Remember that?
Yeah, I remember our conversation.
And I kept asking you whether would a 1% chance of death be enough for this exception to apply? Recall that?
I remember you continuing to ask that question. Yes.
And at one point you told me that 1% was not enough, right?
In my medical judgment, not.
And then you then told me, well, there's situations that are very difficult to decide, right?
There are.
And then you also said that whether 1% chance of death was enough or not enough is really not a question I can answer. Remember giving that answer?
Yes, I remember.
Okay, and then you said, and I asked you, well, if the doctor comes to the conclusion that if they don't perform the abortion right now, there's a 1% chance the patient will die and a 99% chance that the patient will live, can the doctor, under the statute, as you understand it, perform the abortion, yes or no? Remember that question?
Mm-hmm.
You have to say yes or no because
Yes,
I'm sorry.
Yes.
Okay.
We went through this with a deposition too.
Yes, yes. We'll take the show on the road next, sir. Okay. Do you recall that when I asked you that question, maybe the third or fourth time, you said, well, if they follow the proper documentation, the informed consent procedures that are outlined in the statute, they could perform the abortion, right? Remember that?
According to the statute, if the doctor feels that it's in his reasonable medical judgment that there is a significant, let me just read it, is in reasonable medical judgment is designed or intended to prevent the death of the pregnant woman or to prevent a serious risk of substantial or irreversible impairment. And he documents that and does the abortion, then he can. That's what I interpreted that to mean.
So in the course of like that 15-minute section of your deposition, you told me that 1% was not enough, that it was difficult to say, that you couldn't answer the question, and that 1% was enough, right?
Yeah, and you're right. Because it's a hypothetical situation that, and the way that I look at it, probably the way that reason that I answered it that way is because it's out of absurdism. To me, saying that a 1% risk in my practice and in what I've seen other practicing physicians do out in the community, which is what I've been asked to provide my testimony on. A 1% risk to the vast majority of them would not seem a reasonable medical judgment for an abortion. And so it was, I understand where you were going in determining what the risk is. But medicine is not black and white. It can be very difficult to interpret, or to not interpret, it can be very difficult at times to make decisions that do involve life and death situations.
I agree with you, sir. It can be very difficult to make those decisions. Let's talk about the serious risk exception now, okay? And we also sort of had some dialogue about whether you could put a percentage number on how high the risk has to be to qualify as a serious risk. Remember that?
Yes.
And you said in the deposition that, you know, without knowing the precise clinical situation, you couldn't tell us whether a 50% chance that allowing the pregnancy to continue will lead to substantial and irreversible impairment of major bodily function. Was no, right?
Yes,
That's because each clinical situation is different, right?
that's correct.
Some of these clinical situations are very complicated, right?
Yes,
Some of these decisions can be very hard.
yes.
Medicine, as you said, is not black and white.
You're absolutely right. That's why I also testified in my deposition that we use a team approach.
And there's a lot of judgment involved, right?
There's a lot of discussion, yes.
Let's talk for a minute about preeclampsia. That's a condition of pregnancy that can kill a pregnant woman.
She can die from complications of pregnancy, yes.
And it can also make a pregnant woman go blind.
It can.
And terminating a pregnancy will cure the preeclampsia. Right?
Your statement is correct.
Okay.
I would not say it's the standard of care. Abortion, I'm sorry, could you state the question again? I want to make sure I answer.
Terminating a pregnancy will cure the preeclampsia.
If you might terminate the pregnancy, are you saying by abortion, or are you just saying ending the pregnancy, delivering the baby, however you want? Correct. This the recommended treatment for preeclampsia at some point is delivery
At some point, but you could get preeclampsia in 20 weeks, right?
after 20 weeks after the
So, and evaluating whether to terminate a pregnancy due to preeclampsia, there's not a specific endpoint you can just look at, right?
we have to balance the risk benefits, prematurity of the baby versus the mother's conditions.
There are many factors that are involved, and it's an important decision, right?
Yes.
Preeclampsia can also cause blindness, right?
Yes.
And it's your opinion, at least, that terminating pregnancy to prevent blindness would qualify for this statutory exception, right?
When we were in our discussion, the deposition, I thought that blindness could be considered a significant irreversible impairment. Yes.
You don't know whether the state attorney general has to do, you,
No, I do not.
or whether every district attorney in Ohio has that to do.
No, I do not discuss that in the deposition.
And if a doctor wanted to know whether your opinion on whether preventing blindness was a sufficient reason for an abortion was correct, or whether a DA and a jury might come to a different conclusion, I asked you, like, where do they look for answers? And you said, well, they could ask a maternal fetal medicine specialist or a lawyer, right?
They can, yes.
And then I asked you, well, where would the maternal fetal medicine specialist or the lawyer go to try to figure out the right answer to that question? And you said, I don't know, right?
Yes, that's what I guess.
Now let's take a look at paragraph 27 of your application. Let's put that back on the screen.
I just need to get the proper.
Oh, sure. It's tab 3 in the binder.
I've got it.
Terrific.
And I'm all the comments now, thank
Yeah, that's all you need, right? Let's take a look at paragraph 27, which is at the bottom of page 6, going on the top of page 7 of your affidavit. And here, you're talking about melanoma, right?
you. Yes, there was a woman listed on the affidavit who presented with melanoma. Who was told by her doctor she could not receive treatment unless she had an abortion.
And that was because she needed immunotherapy, and immunotherapy is contraindicated for a pregnant person, right?
I don't recall if the therapy was listed in the statement of the affidavit. They just said that she would not get the doctor to treat her. I don't recall it was immunotherapy.
Okay, but I'm correct that immunotherapy is contraindicated for melanoma.
Yes,
Excuse me, let me ask the question again. What you say in your report is that in the case of melanoma diagnosed during pregnancy, immunotherapy is not indicated, right?
correct,
But immunotherapy may well be treatment for melanoma outside of pregnancy, right?
correct.
Okay. And you offered the opinion in your affidavit that no reasonable physician would consider themselves have legal risk for terminating the pregnancy of a patient with melanoma, right?
What I said was, if no other alternative treatments were available other than immunotherapy, in that case, a doctor could believe in good faith that the pregnancy would pose the risk of substantial irreversible impairment of major body function. And that's in that circumstance, no reasonable physician would consider himself barred by the law.
That's your opinion, right?
Yes,
Okay. And you don't know again whether the VAs or the Attorney Generals agree with that, right?
whether they agree with it or not, if it's a criminal intent, don't they go to a jury? I'm not a lawyer. Wouldn't they go to a jury for their peers?
And you don't know what a jury would say on that question either, right?
No, I'm not.
Okay. And in fact, there's actually a lot of uncertainty about how to treat pregnant women with cancer, right?
Yes,
In fact, one of the reports that you included, and you cited in your expert report, talked about how there was an absence of studies, clinical trials, that showed that for cancer patients there was improved maternal survival with termination of pregnancy, right?
that's correct.
That doesn't mean that terminating pregnancy won't help, it just means there's uncertainty, right?
Well, it's been unethical in many cases to perform clinical trials on pregnant women because of the circumstances of the pregnancy.
So it makes it very hard to get data on a question like that.
It does, yeah. It does that for almost anything.
Right.
In the pregnancy.
And deciding whether to terminate a pregnancy for a woman who has an aggressive cancer can be a very difficult decision, correct?
Yes, it is a very difficult decision.
Sir, you don't think any doctor would have to fear going to jail if the medical judgment is questioned, right?
I don't think they should have to fear. I would hope no doctor fears in their medical judgment that they go to jail based on their medical judgment. I would hope they fears, but that's not a reality. That's not a possible reality.
Well, what you said in your deposition, sir, was, quote, I don't think any doctor should have to fear going to jail if the medical judgment is questioned.
Yeah, I think that's what I just said.
Okay.
That was my intention.
All right. But you'd agree with me that under this law, if the district attorney or the state attorney general and a jury disagree with the reasonableness of the doctor's judgment making these difficult decisions, the doctor would go to jail, right?
They could go to jail after a trial where it was found. I don't know what would happen in that case because I'm not a trial attorney or a judge, but what's going to be called into play is my understanding. If this is what you're asking me, was this medical judgment reasonable?
And in your deposition, I asked you, sir, would you agree with me that being exposed to that risk of jail might affect the way doctors practice medicine to make them more conservative about when to choose to perform abortions? Remember I asked you that question?
I don't recall, but if you did, and if you refresh me on my.
Sure, take a look at your deposition transcript should be in the binder that I gave you, sir. And it's in, if you look at tab 2 of that binder, and it's page 1-2.
Yes.
And I asked you that question at line 13. You see that, sir?
Yes.
Would you agree with me that being exposed to that risk might affect the way doctors practice medicine, make them more conservative about when they choose to perform abortion, and they might be left to their own medical judgment, not the threat of going to jail, right?
Yes.
And your response, as the expert chosen by the state to defend this statute, was, I can't speak to that. Right?
I just want to make sure I'm reading your question.
Yeah, it's page 115.
How I respond to that is how I responded to that. And I want to make sure that, where my intention of saying that, what I meant by that. And I think that my response says, I can't speak to that about abortion because I don't provide abortion, but I think every doctor who is making medical decisions faces some consequence of that medical care or some consequence of that.
Right, but this one, the consequence is jail, right?
Which we can face also. If we don't do abortions or not, we just had a doctor who is put on trial for multiple manslaughter. From doing what he felt in his medical reasonable judgment is the appropriate thing to do. He was acquitted.
Right. What we said is when we asked the question about whether this would cause doctors to practice more conservatively because they face the risk of jail and be less willing to give abortion for people like women facing cancer treatment. Was I can't speak to that, right?
No,
Yes.
I don't do abortions, but I don't think I can conservative isn't anything.
I have no further questions.
Dr. Parker, is it possible in your medical practice that you would face a situation where a pregnant woman would have a risk to her life on an emergency basis, where you have to make a decision with her about what to do?
Yes.
For the questions.
So, after. It's a little hesitant to wait because the court wants to leave the presentation matters departments. The court does have one luxury that probably don't have, it's that we can object to the question. So I'm gonna ask the question, I think it's going to be more asked to the not to it, it's somewhat argumentative, but I think the point he was trying to make was that when you agree that the doctor is faced with the dilemma that he's explaining to you. Whether you want to face prosecution or victory felon carries with it one year of prison. The easiest course, the safest course, the most certain default course would be an actual course. Would be to refuse to do the abortion because then you don't have to worry about it. You understand that? Is that the reaction you would expect? But anyhow, choose the safest, most conservative course.
In my experience, when in doubt, you do what you know is the next right step.
Okay. It's not really a question.
Well, the difficulty I have with that question is we're currently acting under that statute very similar to what's in this act that does have the criminal penalty of going to jail. It's actually worse. They may be worse than what we're dealing with right now.
Right, what's that statute, limitation, what's that about, just to make sure everyone.
I believe that's the 20 week.
That's pretty clear, right, right? Not a lot of medical judgment involved whether or not someone's seriously at risk of what level of parents, but what we're trying to get is I have to decide the facts. Supposed to just get it right, I have to decide the facts. One of those facts that's in contention is whether or not it's practical. Doctors faced with this law will generally decline to abortion such that it has the effect of being basically totally impractical effect. And that's really the question. Your testimony is key to that. Your testimony is key to that because you're here to say to the state, no problem, it's okay. But then on the making forget it. You're pretty much conceded. There are a ton of you. In fact, your own exception of what an abortion is under the statute is wrong. What will you heard when all practitioners At least the advice they're getting, the lawyers, the hospitals, advisors, is when it out, don't do it. You don't want to be looking for your shoulder. Or you feel different. That's really what I want.
Well, I do feel different for several reasons. One, it's very rare to face with situations like that. And so we're not faced with these situations many times. And so it's when we're talking about this and the statements that are made, a lot of it's confusing for me because many of the things I'm being asked about don't happen until then.
Or they don't have to be you because
I work in a hospital. Work in a hospital. As I said in my statement, I work in the emergency room, and I haven't come down to emergency rooms and those that work. Okay. And in many times in the situation, let's use for example, a woman who comes in with an inevitable abortion, and is having heavy bleeding. The vast majority of the time that baby is not alive. And the time where it is alive, and we have to do some type of action, we can call people to get that time.
I understand the position in those cases. Patients, maybe
The current hospital system, and that would be situations that are not.
current hospital system, one hospital, you don't have to face that choice. Your system turn policy because I think I understood the definitions kind of. You take those, let them deal with that.
We provide the woman with the information of what's going on with the case. We give her the option of how that case can be used. And as I've said before, that many of these complications that we see are happening with the pregnancy. The one that would not be, would be say, a premature record at 18 weeks. If that woman was not showing signs of infection, and no other reason to deliver her at the time, and she chose to have an abortion, she could be written and ever out of her counseling. If she chose to do that, we would send her to somebody who would perform an abortion.
So that they have the exposure to that.
It's an exception.
I don't doubt it. That other institution would own the risk under this law, not you with yours.
That's correct.
Oh, all right. Well, I think it's fair. Thank you very much. Does anybody have any questions? Triggered by the court's question? No, you're right. All right, thank you very much. Everybody step in there.
Would you like your binder back here?
Thanks so much, Dr. Martinez.
And where do I give this?
You can keep this one, you can use that. Take care.
I'm just gonna say, I do connect with Taylor's rebuttal with this Dr. Stephen Coffey. Dr. Johnson has requested that his picture not be taken or used. So if we could lower the camera, he's hearing raising. Is that possible?
Well, let's just make sure. So you were different cameramen here earlier. Yes, correct. You didn't hear this admonition. I don't know, you need to get consent from different parties to take the picture. In this case, because of the sensitivity of the matter, we're asking that you don't take the picture at all. Because we don't want to have to rely on something that we don't broadcast it. We want to rather not. How's that? That's order or penalty of contempt.
And that is for the coming later.
That's for this one. This is going to appear like it's not going to appear. And how are we going to do that with the live feed that the court has facilitated via Zoom?
That I'm not sure. Is it possible to angle the live feed camera away from the screen that's being displayed?
The live feed is the Zoom.
Can we take a 5-minute break just to figure that out? I appreciate it, Your Honor. Thank you.
Your Honor, I think I can probably short circuit a lot of this. Dr. Duffy has agreed to have his image shown, so he understands.
Make sure he's the person we can't unring that bell.
Yeah.
Yeah. Okay.
I think, and for what it's worth, I do think the live feed that we send on YouTube is a different camera than, it's not just, it's not taking new screen, if that makes sense.
Okay.
I don't know. Okay. I'm comfortable either way, so we can go.
All right. You can go.
Sorry, back and forth.
You can go. I can't.
I believe he needs to be admitted. Oh, there. We have Dr. John.
You did. Yeah.
We have him.
We need to swear to witness. Do that. Make sure you can hear it if we have some issues.
I believe when I spoke into the microphone earlier, prior to this was able to hear me. Dr. Joffrey, are you able to hear me if I speak into the microphone?
I can hear you, although it's not perfectly clear.
So you have an extension.
Sound is just a little garbled.
The witness and the podium.
Should I turn this one off or?
Do you mind if it goes on the shelf up under you? There's a couple shelves on the podium. Excuse me.
All right. No, that's not good.
I think you're muted.
Yeah. Dr. Jaffe? Now can you hear us?
Yes.
There you go. It was this button right here. Okay. Dr. Jaffe, raise your right hand, please. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, all that for the oath. Go ahead.
Good afternoon. Good afternoon, Dr. Jaffe. Could you please introduce yourself to the court?
Good afternoon, Your Honor. My name is Stephen Jaffe. I'm a professor of medical ethics and health policy and professor of pediatrics at the University of Pennsylvania School of Medicine.
And Dr. Jaffe, could you please describe your educational background?
Sure. I was an undergraduate at Harvard College, where I got my degree in art history or fine art. I then went to medical school at the University of California at San Francisco. After completing medical school, I trained in pediatrics, still at the University of California at San Francisco. After completing my pediatrics residency, I got a Master of Public Health degree in epidemiology and public health at the University of California at Berkeley. I then went to the Harvard Medical School, Dana-Farber Cancer Institute, and Boston Children's Hospital to do specialty training in pediatric hematology oncology, or cancer medicine. And while I was doing that, I did several additional fellowships then and immediately after, including a fellowship in medical ethics at Harvard Medical School and a fellowship in professional ethics at Harvard University.
And I believe you touched on this, but what is your current occupation, Dr. Jaffe?
I'm a professor of medical ethics and health policy and professor of pediatrics at the Perelman School of Medicine at the University of Pennsylvania, in which role I serve as chair of the Department of Medical Ethics and Health Policy. I teach medical ethics and I do research in medical ethics.
And Dr. Jaffe, have you published on issues of medical ethics?
I have. I've published, if you look at my CV, over 200 articles in the medical literature, as well as chapters in books. And I would say that the vast majority of those articles are related to medical ethics.
Have you served on any ethics committees?
I have, both at the institutional level, for example, at the Children's Hospital of Philadelphia, at the Dana-Farber Cancer Institute, where I actually chaired the hospital ethics committee for a number of years, and at the Children's Hospital in Boston. And I've also served on ethics committees for professional societies, such as the Children's Oncology Group and the American Society of Clinical Oncology, and on ethics committees for government entities like the Food and Drug Administration and the Department of Health and Human Services.
And can you describe for the court a little bit about what it entails to serve on an ethics committee?
At the institutional level, for example, in the hospital committees that I mentioned, the roles include consulting on clinical cases, difficult cases that clinicians, patients, families are struggling with, or where there are disagreements, and also on issues of hospital policy related to ethical questions. For entities like the Food and Drug Administration, they relate to questions like what should our policies be with respect to pediatric drug approvals, for example, or pediatric research.
Have you held any editorial positions at any peer-reviewed medical publications?
I have. At the moment, I'm on the editorial boards of the American Journal of Bioethics and a journal called Ethics and Human Research. And in the past, I've been on the editorial boards of the Journal of Clinical Oncology and of other journals as well.
And I'd like to bring up what's been marked for identification as Plaintiff's Exhibit 12. Dr. Jaffe, are you able to see that?
I am.
And I'm showing you, like I said, what's been marked as Plaintiff's Exhibit 12. Do you recognize this as a copy of your CV?
I do.
And looking at this, is this a true and accurate copy of your CV?
It is.
And plaintiffs would move to admit Exhibit 12 into evidence. And at this time, plaintiffs would tender Stephen Jaffe as an expert in medical ethics. Dr. Jaffe, turning now to your expert opinion in this case, have you reviewed the expert report of Dr. Sullivan?
I have.
And have you reviewed Ohio Senate Bill 23, the law at issue in this case?
I have.
Were you asked to respond to Dr. Sullivan's opinions on medical ethics as they pertain to SB 23 and abortion?
Yes.
And could we bring up Exhibit 11, please? All right, Dr. Jaffe, I'm showing you what's been marked as Plaintiff's Exhibit 11. Do you recognize this document?
I do.
And is this the expert rebuttal report that you submitted in this case?
It is.
Your Honor, plaintiffs would seek to admit Exhibit 11 into evidence at this time. Dr. Jaffe, turning to the opinions you state in your report, Do you agree with Dr. Sullivan that medical principlism uses four widely accepted principles?
I do agree that the most widely used framework for thinking through medical ethical challenges involves the use of four principles to analyze medical ethical problems.
What are those four principles?
The four principles include the principle of respect for the autonomy of patients, for their decisions that they might make about accepting or not accepting medical procedures, and decisions that they might make about the course of their own lives and how medical interventions might serve that course. The principle of beneficence, in other words, the physician's or clinician's obligation to look out for the best interests of patients and serve their best interests. The principle of non-maleficence, which translates as the principle of avoiding unnecessary harm or trying to minimize the risks and harms of medical interventions or procedures. And finally, the principle of justice, which requires that we think about how the benefits and burdens of medical treatment are distributed fairly across different individuals and groups of individuals.
Understanding that you agree with Dr. Sullivan about the four principles of medical ethics in this framework you describe, what is your opinion about Dr. Sullivan's application of these principles in the case of SB 23 and abortion?
I believe that Dr. Sullivan misapplies the principles of medical ethics in his analysis of this case and in his opinion. In particular, he asserts the principle or the importance of non-maleficence towards the fetus or the embryo, and asserts that it has almost absolute priority over the other principles that are important and central to medical ethics, even after acknowledging the need to balance the principles of medical ethics in a particular case. And as a result, the importance of other considerations, except in the extreme case of a pregnant patient, of a woman who is threatened with threats to her life or serious threats to her health, the interest, the considerations, the respect for the pregnant patient's autonomy, the interest in her well-being do not factor much, if at all, into Dr. Sullivan's balancing. And for that reason, I believe that although he identifies the principles correctly, he misapplies them or misuses them in this case.
What is your opinion about the weight Dr. Sullivan accords the moral status of the fetus in applying the principle of non-maleficence?
Dr. Sullivan accords the fetus or the embryo almost absolute weight and accords that moral status. He asserts the moral status at a very early stage as a given, and then gives it almost absolute weight in the weighing and balancing of principles, such that other considerations, the respect for the autonomy of the pregnant patient and the health and other interests of the pregnant patient, figure very little except in these extreme cases of serious threats to her life or health.
And what is your opinion about the weight Dr. Sullivan accords patient autonomy in his application of the four principles in the case of SB 23?
Dr. Sullivan appears to assert very little weight to the importance of patient autonomy, which is one of the central principles of medical ethics, and yet it barely appears in his opinion at all. It is given very little weight as compared to what I believe he weights much more substantially, which is considerations of non-maleficence towards the fetus or embryo.
Dr. Jaffe, how would you characterize the primary distinction between your expert opinion on the application of medical ethics and Dr. Sullivan's opinion on the application of medical ethics?
In my view of medical ethics and in my application of medical ethics to this case, what I believe is centrally important, what I think most medical ethicists would hold as centrally important, is respect for the diversity of views, diversity of perspectives, diversity of commitments that different patients would bring to the medical encounter. So in my view, if a patient is deeply committed to the moral status, to an embryo having personhood from a very early stage in gestation, my view of medical ethics would be deeply respectful of that and would say that the physician or the clinician should act in accordance with that. But if another patient comes with a different view of the moral status of the embryo or fetus, I believe it's really important, and I think most medical ethicists would say that it is really important that that be respected as well. On the other hand, Dr. Sullivan brings his view of the moral status of the fetus or embryo, which is near absolute, and essentially wishes to impose that on all patients, no matter what their personal, religious, spiritual, philosophical commitments might be.
No further questions, Your Honor.
Hello again, Dr. Jaffe. I'm Amanda Narog with the Ohio Attorney General's office, and we spoke at your deposition just a few days ago. So I just have a couple quick questions for you.
Okay.
Isn't it true that in the original Hippocratic Oath that abortion was prohibited by a doctor?
The original Hippocratic Oath, which is over 2,000 years old at this point, does have a statement prohibiting the use of abortion by a physician. Although again, the Hippocratic Oath is a medical ethical set of principles from over 2,000 years ago, and the principles of medical ethics have evolved substantially since that point. But yes, it is true that in that case, there is a statement with respect to abortion in the Hippocratic Oath.
And you would agree that the point of conception is one potential event that could signal the beginning of human life?
The point of conception is an important milestone in the development of a being that has the potential to go on to become a human being.
And you don't believe that there is one single truth as to when human life begins?
I believe there is a great deal of diversity. I'm going to use the term personhood when a being becomes a person. And I believe that there's a great deal of diversity of moral views that individuals have based on their personal, philosophical, and religious and other commitments about when personhood begins. So there is no single fact of the matter about when personhood begins in the course of development through pregnancy.
So you would agree that there is disagreement on the question, even among physicians?
Are you asking me about physicians' personal views?
As to when life begins?
I would just reiterate what I said a moment ago, which is that there is a great deal of diversity based upon people's different personal and philosophical and religious commitments about when life begins, when personhood begins, and how moral status evolves. And there is no science, there's no single truth of the matter or fact of the matter about when personhood or life begins.
And there's even disagreement as to when human life begins among medical ethicists, correct?
Medical ethicists may hold diverse personal views about when human life begins based on their own philosophical and religious and other commitments.
But there's no universal view as to what medical ethics says about when life begins. Is that correct?
There is no single scientific fact of the matter about when human life begins.
Do you dispute that at the point of fertilization, when a sperm and an egg fuse, that cell or cells has a unique and new genetic profile?
That cell, that fertilized egg has a new genetic profile. Again, that may split to go on to become twins or triplets. That is possible. So that is not necessarily one unique being. And there are unique or rare situations where actually two fertilized eggs or two very early embryos may fuse and become to what would have been two would become one. So there is no one-to-one relationship between that. There's no necessary one-to-one relationship between that fertilized egg and a subsequent human being.
But that genetic profile is different from that of its mother and its father. The two people that came together to create that unique genetic profile.
That genetic profile is different from its biological parents, yes.
And you don't feel that there is an objective point where an unborn child has moral status?
There is no single objective point where a fetus or an embryo has moral status.
But the moral status of a fetus is a deeply value-laden, spiritually laden, religiously laden, and even philosophically laden question.
It is one about which different people who bring diverse and different views to the context, to the table, will have very different views about the moral status of an embryo or a fetus or fertilized egg at different points in gestation.
And those values are legitimate considerations when we think about these questions, are they not?
Those values, from a medical ethics point of view, those values are central to the conversation that happens and that ought to happen between the doctor or the other clinician and the patient in making decisions that are respectful of the values of that particular patient, given her medical situation, her personal situation, and her values.
And isn't it true that during your deposition, you acknowledged that the most important values or commitments of medical ethics is a respect or recognition for the diversity of views of different people and what they bring to these important medical questions?
I don't recall my exact words, but I do believe that it is central to medical ethics to be respectful of the diverse values that different patients bring to medical encounters and to the medical questions that they face.
And again, you would agree that there is not a single universal consensus on when life begins?
To reiterate, I believe that there is a great diversity of views among different people about when life and personhood begin.
So there's no single universal consensus on that issue?
There is a great diversity of views on the issue of when human life and personhood begin.
No further questions, Your Honor.
Thank you, Very good. Thank you, Dr. Chapman. Your excuse. We appreciate your time.
Thank you, Your Honor.
Next witness.
I believe that's all the witnesses that the plaintiffs have at this time.
Any rebuttal witnesses?
We have further witnesses either.
So all the evidence that we're going to receive is going to present. You're prepared for closing arguments? You want to take a short break?
We can take
Okay. Let's take a 10-minute break or so and then get back here and wrap this up on time. If you could both, before we begin, after recess, make sure you have a list of your exhibits that have been moved and admitted, or any of the work that we deal with.
Yes, thank you.
We're in recess.
submit. In fact, when you do something as simple as take a Sharpie. Maybe do the Sharpie on the back as well. Before you submit your evidence to court order, she takes custody of the exhibits at the conclusion of the hearing. Just make sure that's done. The exhibits get.
Thank you.
Anything else?
Not related directly to exhibits, one, just for clarity of the record, the state defendants do have copies of the bench motion on the waiver issue. Are we going to send those claims counsel in court this time?
A copy of a bench memo on the what issue?
Motion on the waiver, the documentation waiver issues, that's what.
Okay, so what does that have to do with whether or not there were waivers or not? Since no objection was interposed to the presentation of that testimony on the basis of waiver or not, what does that have to do with anything before the court? I guess I'm wondering, what does it matter? The only objection was made to the testimony of the folks about what they observed as abortion providers or working in abortion clinics, was that some of it wasn't first-hand knowledge. The court overruled that motion. So what does the waiver or not waiver have to do with whether the court can receive that evidence considered?
Sure, Your Honor, and I apologize if there was a misunderstanding. I think it was Ms. Neron's intention and our intention to make a separate motion earlier on the documentation waiver issue. I understand that you overruled that motion. You just
but no, I didn't overrule that motion. It wasn't made unless I totally blanked out.
Okay.
Was there a motion made about waiver or not waiver?
Your Honor, I did attempt to move orally at that time to exclude the testimony regarding patients' information that is provided about waivers being obtained from the patients. And in that process,
The information had already been listed. No objection was raised. I mean, the time to raise your objection is when someone asks the question. And elicits it, not on cross-examination.
well, we were unclear until at least the depositions as to whether they had actually obtained waivers. And so that is when we elicited that testimony here in court, then to object to the testimony because we had to confirm there was not a waiver in the record in order to.
But you asked that in depositions, you already knew.
We have been told that some waivers were obtained, but they were not provided because they apparently were not responsive to our discovery requests, even though patient records were relied upon. So we were just following the format that we felt was most appropriate during this hearing.
Well, that's unfortunate because my understanding was from the depositions that I read. Was that information about whether waivers have been obtained or not was listed during the depositions, at least the ones I've read. They're all the ones that I was provided. And therefore the time to object on a non-waiver or waiver, if that isn't grounds for objection, would have been when the plaintiff sought to elicit testimony. The court's perception of the inquiry that you were making on waiver or non-waiver was that it was intimidating, that it was designed to raise the specter of some consequence of presenting this information without having gotten a waiver, which was inappropriate since no objection had been proposed to the elicitation of that very testimony on the record. That's why the court received it the way it did, was because you failed to object in the time to pass. You know the rule, failure to object is a waiver of the objection. No objection was proposed. You knew about the waiver. You waived the objection. That's the court's rule. You can submit the bench memo. It will be part of the record. Your objection after the fact, after the court ruled to waive it, is noted in the record. There. Very good. All you have to do is tender that to Mr. Patrick, the bench memo, make sure that it goes inside, gets a copy of it. We'll make sure it's made part of it. That's one. Very good. Anything else? You just do it before we close the hearing. All right, let's start closing the record.
Your Honor, after almost a full day of evidentiary hearing and extensive briefing, defendants have no real answers to plaintiff's legal claims or their showing of severe harm to Ohioans from SB 23's draconian criminal abortion. Quite simply, plaintiffs here have met all requirements for preliminary injunction. First, and most importantly, plaintiffs have shown a substantial likelihood of success on the merits of our claims. SB 23 violates the right to abortion protected by Article 1, Sections 1, 16, and 21 of the Ohio Constitution, as this court has already done. That is the law of the case. That is all they are. In addition, the plaintiff's abundant evidence has shown that the fundamental right to abortion has been severely infringed by SB 23. First of all, SB 23 is a near total abortion ban. It bans abortion at an extremely early point in pregnancy, with no exception for rape, incest, or fetal anomalies. Dr. Liner testified in her expert capacity to the fact that many women do not even know they are pregnant until after 6 weeks. And that certainly, even for those who do, many cannot access abortion by that point. Other evidence in the record backs this up. In particular, a study of the likely impact of a 6-week ban conducted in Ohio before SB 23 was in effect found that 89% of people in Ohio access abortion care after 6 weeks. Dr. Liner's testimony was to similar effect, and this fact was not disputed. In addition, the right protected by the Ohio Constitution is infringed by SB 23 because of the way that it harms women and patients' bodily integrity and reproductive autonomy. We've heard today, and we've heard having the record, and we heard in the TRO hearing horrific stories of patients who were harmed by SB 23. Stories of lethal fetal anomalies that patients would be forced to carry to term under SB 23. 10-year-old rape victim who was forced to travel out of state, all of these stories. Patients being denied abortion in the face of serious health risks. However, even setting aside these situations, SB 23 inflicts severe harm on the life chances and futures of Ohioans. There are, of course, glaring deficiencies in the law and in its exceptions and its lack of exceptions. But even setting apart the question of the exceptions, SB 23 denies bodily integrity and autonomy to Ohioans, and particularly to women in Ohio. Dr. Liner also testified as to the health risks and physical strains inflicted by pregnancy, any pregnancy, and risks that aren't addressed by the statute, but also just the risks and harms imposed by normal pregnancies that increase patients' likelihood of hypertension, blood clots, other complications. Pregnancy can both exacerbate pre-existing health conditions and trigger serious new health conditions. Again, none of this was rebutted successfully by the defendants. They have not succeeded in rebutting this evidence that abortion is safe and significantly safer than childbirth. In fact, plaintiffs introduced the report of the National Academies of Science, which is Exhibit 19, plaintiffs Exhibit 19. This authoritative source, which is the product of years of work by a committee of experts, proves that abortion is 12 to 13 times safer than childbirth, as Dr. Liner pointed out as well. Thus, because plaintiffs have shown that the fundamental right to abortion is at stake and that SB 23 infringes on that right, it is a heavy burden on that right. The remainder of the burden rests on the defendants. The burden on the defendants is to show that the law meets strict scrutiny in that it is narrowly tailored to advance a compelling federal interest. Defendants have not met this burden. To the extent that the defendants suggest that an interest in fetal life is the government's compelling interest here, they point to nothing beyond the purely moral claims of Dr. Sullivan that the interest in fetal life can overcome the woman's interests in bodily integrity and reproductive autonomy. We cannot show that those interests, that the state's interest overcomes women's interests, especially at the early stage of pregnancy. And in fact, plaintiff's own experts agree that this is a highly disputed ethical proposition. That the moral status of the fetus and the value of the fetus. Dr. Sullivan noted that there is a lot of disagreement about the value that should be placed on fetal life. Dr. Jaffe, in rebuttal, recognized that this is an instance of the state imposing its own moral view about the mere absolute value of the fetus as compared to the value of the woman's life and the woman's future and bodily integrity. And that this is a question where there is a diversity of moral, religious, and philosophical views. The state does not have a compelling state interest in imposing one view, its own view, on Ohioans on that disputed matter, especially in the face of the tremendous harm that plaintiffs demonstrated today. As far as narrow tailoring, Your Honor, defendants have not even attempted to address this from the defendant's own expert, Dr. Sullivan, has agreed that the state could, if its goal were to reduce abortions, could improve comprehensive sex education access, contraception access, and so on. Finally, Your Honor, I want to address the prong of irreparable harm in terms of the preliminary injunction standard. Again, the court has reported numerous affidavits showing the harm to patients from SB 23. This is the harm that the plaintiffs point to in supporting and showing of irreparable harm. Although we did in fact seek a temporary restraining order in September because of the impending closure at one of the clinics, that's certainly what precipitated the emergency relief we were seeking. The irreparable harm that plaintiffs rely on at the preliminary injunction stage is the harm to patients, their physical and mental health, and to their bodily integrity and reproductive autonomy. As Dr. Miner explained in her expert report, again, there can be numerous harms to health from pregnancy, but in addition, being denied an abortion can be financially destabilizing, particularly for people who are already living in poverty. There is harm to other children in many instances, and an increased risk of staying with a violent partner when people are denied an abortion that they should have. Of course, again, the defendants cannot dispute this evidence and have not successfully disputed this evidence. And then finally, Your Honor, both patients and providers are harmed by the vague medical exceptions contained in the statute that they cannot understand and that chill their provision of care because of their fear of felony criminal penalties. Again, defendants' witnesses, defendants' experts essentially agree on this point. Both Dr. Sullivan and Dr. Parker acknowledge that it's difficult to say exactly what these exceptions forbid and what they allow. Dr. Sullivan acknowledged he didn't know what it was like to practice medicine under the threat of felony conviction. And that he couldn't really say because he had never provided abortions. Similarly, Dr. Parker's testimony demonstrates that what a reasonable physician thinks is allowed under the law is not necessarily what the law says is allowed. And he again affirms that it's very difficult in on-the-ground situations to actually determine how substantial the health risk needs to be, that it can be very difficult to make these sorts of life or death decisions, that each situation is different, hard, complicated, not black and white. This harm, of course, in the form of the threat of felony penalties for providers becomes also the harm to patients who are denied abortion when the doctors can't figure out what it is. So, Your Honor, plaintiffs have shown a substantial likelihood of success on the merits of our claims. We have shown that providers are harmed and that patients are harmed irreparably by SB 23. The remaining factors, which are harm to third parties and public interest, also fall in plaintiff's favor here. Because given our likelihood of success on the merits, the defendants cannot show harm to the parties or to the public. The public interest is served by protecting constitutional rights. In conclusion, then, we ask the court to grant a preliminary injunction to prevent the severe, ongoing, irreparable harms that SB 23 is causing to Ohioans and to their rights under the Constitution. Thank you.
Yeah.
Your Honor, as my co-counsel made clear in his opening statement, it was the plaintiff's burden here today to demonstrate that they are entitled to a preliminary injunction by clear and convincing evidence. They have failed to meet that burden. For the reasons provided in the state's brief in opposition, it is the state's position that the only plaintiff withstanding to challenge the Heartbeat Act is Dr. Sharon Liner. Dr. Liner's testimony demonstrates that she understands the requirements of the Heartbeat Act and the exceptions provided by the law to protect the life and the health of the mother. Dr. Liner's testimony further demonstrated that limitations on her performance of certain abortions are self-imposed community standards and are not as a result of the language of the law. She also testified that she performed an abortion while the Heartbeat Act was enforceable, after a fetal heartbeat was detected pursuant to an exception under the law. She has not been prosecuted, nor has she even been questioned by any enforcement authority, including the Department of Health or the State Medical Board. Her testimony demonstrates both that she is not at risk of prosecution, she has not been subject to prosecution, and that she has self-imposed additional guidelines on her practice of abortion, such that she has not shown that she will violate the law. Therefore, she hasn't shown by clear and convincing evidence that she has been or is threatened with an injury in fact. Without showing of injury in fact, she can neither challenge the Heartbeat Act herself, nor can she meet the requirements of third-party standing to advance the rights of patients. Now, to the extent that we have discussed the vagueness issue in this litigation, that is not the basis that plaintiffs have moved for the preliminary injunction on this motion at bar. So we would ask that the court disregard to that extent in its consideration of the motion. For these reasons, and in concert with the arguments advanced in the state's brief in opposition, the state respectfully asks the court to deny the preliminary injunction motion at bar. Thank you, Your Honor.
Very good. Any rebuttal? All right. So we have the evidence in place and we have closing arguments. Counsel, I think I alerted lead counsel to the court's quandary prior to the hearing that it seems that while we have gathered a significant amount of information during today's hearing, there isn't anything new and unexpected that wasn't already before the court in some form or another. And so while if either party wants to submit a post-hearing brief, going over the evidence of record and reiterating the arguments that are already been made repeatedly, that's fine. But the court is prepared to rule at this time, subject to a further injury if the parties want to waive further submission. But again, in order to give every party a fair and full opportunity to make every argument that they think is appropriate, we won't do that if either party wants to take additional written submission. Given the constraints of time, though, that submission will have to be done very soon. The existing temporary restraining order, unless I'm mistaken, will dissolve on its own terms, I think on the 12th. Today is the 7th, so that's 5 days from now. So ask each of you to tell the court whether or not you want to make additional submission to the plaintiffs.
Your Honor, no, plaintiffs do not need to make a discussion.
Defendants,
Your Honor, do you mind if we just call our clients quickly? And just, I don't think we would, but and just confirm it.
that's fine, that's fine. I will take this opportunity to tell you that the court, I don't want to use the word disappointed, that I wasn't disappointed. I was a little bit surprised that after I admonished the parties during one of the status conferences, the court's basic statement of the law in the temporary restraining order decision was the law of the case. That rather than direct efforts to that some of the parties simply retread the same arguments they made before, which weren't accepting that law as the law of the case at this point. If you want to attack this court's rulings on what the law is at this level, the place to do that is at the next level. The court is not going to depart from the rulings that it's already made, the law of the case. In fact, to do something different would be inappropriate, because that really set the stage for what we were supposed to present today. So if that helps you decide whether to make further submissions or not. That's one. All right, we're going to take a 10-minute recess. Let us know whether or not you want to make another submission. If not, go to a roll.
Sharpie.
No, I mean, but I have a markers. I got blue, red, green, and blue. You know.
We need like a.
All right.
Back on the record. First item that I want to address before we proceed is the state's, what was referred to on the record earlier, the bench model was actually presented to the court just now as state defendants. We excuse these typos because we're very sympathetic, because this has all been an error. So there's misstatements in the titles and whatnot. Don't worry about that at all. But it's couched as a motion in limine regarding patient communications. The state has sought to exclude various items, testimony and affidavits under Ohio Revised Code 13-1702 dealt with this a little bit earlier, but since it's been interposed as a motion to eliminate after the presentation of the evidence, which is not exactly when it should be done. If I give a motion, it needs to give us all the preview of the issue or a chance to deal with it before the information is presented. This is what we're dealing with. The court had an opportunity just now to review the motion. I understand the motion. I don't know if the plaintiffs have received a copy of the motion.
Your Honor, we did just copy this now.
All right. Well, the basic thrust of the motion is that testimony regarding some of the circumstances observed by the abortion providers constitutes disclosure within the physician-patient relationship, and that's prohibited by Ohio Statute 2017-02C. The court's going to overrule the motion coming on record for a couple of reasons. First of all, as we said earlier, the appropriate time to advance this motion would have been along with the other motion. Now, we can't fault the state too much for that. This was a hurry of proceeding, so it's sympathetic. But the state was able to advance the motion. And then another issue, the court does find that the state was aware of this issue for whatever reason, perhaps strategic, perhaps not, chose not to advance the motion before it. At the time this testimony was presented today during the hearing, the state chose not to object to the presentation of that testimony. Instead, preferring to allow it to come in, allow the testimony, particularly by Dr. Long, and then on cross sought to apparently lay the foundation to make a motion to exclude it after the fact. That again is a very poor strategic choice. If testimony is indeed admissible, the time to interpose the objection is when it's being offered, especially when you know it's being offered. So waiver is the first grounds for the court's overruling the motion. The second ground goes a little further. The court's aware of the first district's decision in Roe versus Planned Parenthood, the Southwest Ohio region. This is a August 24, 2007 decision dealing with an individual abortion case where this was where for whatever reason the court ordered a large disclosure of redacted information by the abortion provider for the was provided to minors, devoid of identifying information. The state's argument in this case means that it doesn't matter if the information is devoid of identifying information. If it comes from a physician-patient relationship, it's absolutely off limits of the statute. That's not what the case is. And in that case, the court actually went so far as to say that there was no necessity for the information in the case. It wasn't relevant. And that the privacy interests of those who were subject to the information far outweighed any interest or need for the information in the case. The exact opposite is true in this case. Entirely. First of all, there's no identifying information available from the testimony of the information that has been received. The court's finding that it would be impossible, entirely, at least virtually impossible, to identify any of these individuals whom we heard information. And the court is very sensitive to this issue. This is an issue near dear to this court, having wrestled with this issue in other cases, being very familiar with the Supreme Court's decision in Fetal, and having handled several cases for competent bench involved in exactly these issues. The court is fully satisfied. There's absolutely no risk to the individuals who are subject to the information that was disclosed. And of course, this case will go on. The parties can wrestle with the issue more if they want to discover it. We will deal with it in using in-camera proceedings if necessary, or whatever other measures are appropriate to do. But at this time, the motions are ruled, the evidence is received. Okay, so that disposes of that issue. The other issue before we run off the record is whether or not we're going to make further submissions. Plaintiffs have indicated they don't want to. Where is the defense on this?
You're on the state defense will also not make further submissions.
All right, very good. Well, an important issue is ruling from the bench at this time. First of all, counsel should be commended for an excellent job of presenting the very expeditious fashion of challenging the case. All counsel should be doing a fine professional job. The court was impressed and read every deposition, manner in which all counsel conducted themselves, the manner in which they accommodated one another, the professionalism in which they approached the issues in this case. Everyone is to be commended. It's a difficult, contentious, and a significant case. Courts consider the evidence that we received today, and also the affidavits, other evidence presented before, temporary restraining order. All of that evidence is part of the record that the court considers whether it's rendering this ruling today. Before the court launches into some notes that I have written, I think perhaps the most compelling testimony that the court received today was that of Dr. Parker. I think that it demonstrated unequivocally that one of the most salient points in this entire case which is that it is extremely difficult to be a practitioner in Ohio under this law. And that it would be extremely difficult, and I think doctors to be credited with his honesty, acknowledging this, dealing with the issues. That this law creates a great deal of difficulty for practitioners, puts them in a terrible position, trying to choose between themselves and their own interests in delivering the health care that they probably very much want to deliver to their patients. So that testimony was quite striking, I suppose. But stepping back and talking about the legal issues, this case presents the court with a unique opportunity for public engagement and to build understanding of the judicial system and fundamental organizing documents and principles of the state of Ohio. In overturning Roe versus Wade earlier this year, the Dobbs decision, the new majority of the Supreme Court picked up on a trail of legal breadcrumbs that were being left by the late Justice Rehnquist, starting in 1989 in the Webster decision, and continuing through the dissent of Casey and the majority of Westbrook versus Washington in 1997. Now, the drafters of our federal constitution set out to create a framework for the national government, giving them broad powers in certain areas, specifically providing the federal law is effectively supreme, practically adopted and expressed supremacy clause. But they could not get a majority of the delegates to agree to passage without also adopting the Bill of Rights. That listed areas in which the new federal government could not intrude. We are all familiar with some of those rights: free speech, press, religion, or against self-determination. They also included the Ninth Amendment, which simply states that, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, end quote. The goal here was to make clear that just because the Constitution, quote, enumerates or lists certain specific rights, that this does not mean that there are not other rights. So it is simply wrong to state, as many do, that a right does not exist because it is not specifically listed in the Constitution. The Constitution itself says so. It says that that argument is wrong, because the framers recognized quite clearly that they could not foresee the future, certainly not for the 250 years that we are coming up. These rights, just as real and just as protected as those specifically listed in the Constitution. Constitutional scholars call these unenumerated rights, and they include many of the rights that we all take for granted every day, and that many people assume are actually listed in the Constitution, but they aren't. For example, the right to travel, the right to marry, the right to vote, the right to privacy. These rights have been recognized by the court over time, often evolving and changing. In the case of abortion, being recognized in 1973 and then unrecognized in 2022. This process, whether you like it or not, or agree with it or not, is simply a fact of how our system works. As time passes, society changes, as does the court, and so do our rights under federal law. It occurs in many different areas of the law and is not limited to abortion, even though that issue garnishes a great deal of attention and throws a spotlight on the process. But we also have a state constitution. It is quite different from our federal constitution. Adopted in 1851 and amended over time, Ohio's constitution also contains a Bill of Rights, albeit a much longer list than the federal constitution. It is not at all unusual for a court to consider whether the rights protected under Ohio's constitution extend farther than the federal constitution. It's exactly what Ohio courts are supposed to do in a case such as this. And we are specifically instructed on this by the Ohio Supreme Court in the 1993 decision in Cleveland versus Harmon. Quote, the Ohio Constitution is a document of independent force. In the areas of individual rights and civil liberties, the United States Constitution, where applicable to the states, provides a floor below which state court decisions may not fall. As long as state courts provide at least as much protection as the United States Supreme Court has provided in its interpretation of the Federal Bill of Rights, state courts are unrestricted in affording greater civil liberties and protection to individuals and groups. And in short, This court is following the express mandate of the Ohio Supreme Court when it considers the effect of the Ohio Constitution. Some of the relevant language in the Ohio Constitution is similar to the federal Constitution. Other parts are very different. So it can be helpful to consider how the federal Constitution has been applied. But where different language is in play, that language dictates the result. Now, many people are familiar with the famous words. We hold these truths to be self-evident, that all men are created equal, that they are endowed by the Creator with certain unalienable rights. That among these are life, liberty, and the pursuit of happiness. Well, that's not in the Constitution. That's the second sentence of the Declaration of Independence. Now, back in 1857, talking about the famous Supreme Court decision, the Dred Scott decision, Dave Lincoln over here has something to say about this phrase, how we should think about it today, or as he called in the after times. This is Dave Lincoln. The assertion that all men are created equal was of no practical use in effecting our separation from Great Britain, and it was placed in the Declaration not for that, but for future use. Its authors meant it to be, thank God, for it is now proving itself, a stunning block to those who in after times might seek to turn a free people back into the hateful paths of despotism. That's Abe Lincoln talking about the liberty interest expressed in the Declaration, which was the foundation for the Equal Protection Clause, both in the U.S. Constitution and in Ohio's Constitution. He warned us of the hateful path of despotism and said that this language was intended to give future courts like this one the power to protect us from exactly that. Now, in a similar fashion, about 100 years later, in 1949, Justice Felix Frankfurter himself, no fan of judicial activism, he reasoned that, quote, great concepts like, quote, liberty were purposefully left to gather meaning from experience, for they relate to the whole domain of social and economic fact. And the statesmen who founded this nation knew too well that only a stagnant society remains unchanged. End quote. So the Constitution was drafted with language that was chosen because it is intrinsically capable of embracing then unforeseen rights, because the framers realized that it needed to if it was going to work. The same language from the Declaration, albeit somewhat expanded and probably really improved, is included in the Ohio Constitution as the very first item in the Bill of Rights. And remember what a Bill of Rights is. It's a list of the areas in which the government cannot intrude if the people's rights are protected. The first item of the Ohio Constitution's Bill of Rights says, quote, all men are by nature free and independent and have certain inalienable rights, among which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and seeking and obtaining happiness and safety. That's the very first item of the Ohio Bill of Rights. Ohio's Constitution specifically and unambiguously recognizes as fundamental and inalienable the right to liberty, the very thing that we deprived of since Bill 23, and the right to seek and obtain safety. I ask everyone to ask themselves a question. Does a law that prevents a cancer patient from getting life-saving treatment impair that right? Obviously it does. That's exactly what this law is. The state has provided no answer to the evidence that cancer patients have been denied treatment, because even though they should be able to, under the language of this law, the practical effect of the law, because of the way it's written and the penalties it attaches, is that Ohio doctors who do procedures after 6 weeks LMP are exposed to criminal penalties. Now, Ohio's Constitution goes on. Section 7 of the Ohio Bill of Rights addresses, quote, rights of conscience, end quote. This provision says in pertinent part that, quote, No preference shall be given by law to any religious society, nor shall any interference with the rights of conscience be permitted. End quote. Note the nor. It's a disjunctive. Now consider the rights of conscience. What does that mean? Well, the Ohio Supreme Court told us in the year 2000 in the Humphrey decision. There's a quote from the Ohio Supreme Court. We find the phrase that brooks no, quote, interference with the rights of conscience, end quote, to be broader than that which prescribes any law prohibiting free exercise of religion. The Ohio Constitution allows no law that even interferes with the rights of conscience. Those are the words of the Ohio Supreme Court, recognizing that on this score, the Ohio Constitution goes much farther than the U.S. Constitution by embracing rights of conscience. That's the law this court is required to follow. So does a law that effectively forces a woman with stage 3 cancer to forego life-saving treatment, or which forces a young rape or incest victim to continue a pregnancy, does that law, quote, interfere with the rights of conscience? Obviously it does. In Senate Bill 23, the General Assembly effectively decided that the woman's life and well-being is less important than a non-viable 6-week embryo. If that decision is not an exercise of the rights of conscience, it is difficult to imagine what is. Now, before any counsel jumps up or critic points out that Ohio courts have read the right of conscience to be limited to the religious context, I know, but I disagree. Vehemently disagree. I disagree because of the language. I said note the nor. Well, it's a nor. In other words, not just religion, nor the right to conscience. To do what those courts would do, you have to ignore the plain text. You don't do that if that's the reason that that's what you want to do. But we're not going to do it. Even so, this court is not relying solely or even heavily on this provision as the basis for its decision, but it is one of the many provisions in the Ohio Constitution when read together as we are supposed to, that makes it clear the breadth and depth of our constitutional rights as Ohioans, and that extends much further than under the federal Constitution. Now, really more as an aside than anything else, because this right has been read to be limited to the religious context by some courts, I think it is fair to ask whether it is consistent to hold that a bakery owner with strong religious beliefs who does not want to comply with anti-discrimination laws doesn't have to comply with those laws, while a woman whose life is being threatened with some condition and who may have no religious beliefs that affect abortion, or may subscribe to a faith that does not believe that abortion is an offense, as we heard today about the diversity of viewpoints. Whether that's consistent or coherent, I don't think it is. Again, that's not the crux of the court's reasoning, but it's a point to be considered. And it's not even the end of the story. Ohio's Bill of Rights also includes right number 21, which is titled The Preservation of the Freedom to Choose Healthcare and Healthcare Coverage. That's right. That amendment by popular referendum is part of Ohio's Bill of Rights. Again, it's where you put in if you want to act as a limit on state power. And so this law, this healthcare freedom amendment, it got into the Ohio Constitution in 2011 and it was amended by popular referendum. It seems from the record that this amendment was pushed by certain groups opposed to the Affordable Care Act, or as it's also known as Obamacare. This court is constrained by the actual language that was employed in the amendment. I would simply ignore it on the notion that it wasn't intended by its proponents to apply to this situation. That's not how it works, which is perhaps a lesson to us all. Be careful what we wish for. Here's what item 21 of the Ohio Bill of Rights says in pertinent part. No federal, state, or local law or rule shall impose a penalty or fine for the sale or purchase of health care or health insurance. That's the language of the Ohio Constitution put there by the people. As we heard today, there is not any legitimate dispute that abortion is a medical procedure. And as illustrated by the cases we discussed here today, it is undoubtedly healthcare. For the 10-year-old rape victim, whose body is probably incapable of carrying pregnancy to term or surviving childhood. Abortion is healthcare. For the cancer patient, you can't get life-saving treatment without first getting an abortion. Abortion is healthcare. For the woman with an ectopic pregnancy, abortion is healthcare. In each of these cases, that healthcare was denied because of SB 23 and the criminalization of medical judgment. Now, it's no meaningful response, as the state argues, to point out that doctors face potential financial liability every day if their care falls below standard care. They buy insurance for this, which we all effectively pay for through health risks. But this law raises the stakes exponentially, making it a felony to perform a procedure after the detection of embryonic cardiac activity, unless one of the exceptions apply. What doctor is going to make a close call when the potential consequences of being second guessed after the fact? We know this one, the politically motivated person does that. When the consequences are professionally existential. Certainly none of those doctors have come today. Circling back to where I started, remember the unenumerated rights. Just like the US Constitution, the Bill of Rights and the Ohio Constitution includes a specific provision for the recognition of fundamental rights that are not specifically listed in the Constitution. It's the 20th item in Article 1 of the Ohio Constitution, the Bill of Rights, and it says, quote, "This enumeration of rights shall not be construed to impair or deny others retained by the people." Just like the US Constitution, the Ohio Constitution foresaw that additional rights will need to be recognized. Now, the state argues that the only rights that can be recognized that are not specifically set forth in the Constitution are those that are, quote, "deeply rooted in the history and traditions of our state." But the Constitution doesn't say this. Neither one of these. The 9th Amendment of the US Constitution doesn't say this. The 20th Amendment or 20th Bill of Rights of the Ohio Constitution doesn't say this. So where does this idea come from? That an unenumerated right, a new right, has to be something so deeply rooted that it's beyond question. We all know it exists. Well, it comes from judges who are opposed to the recognition of these rights. It's a judge created idea. And these judges set up a jurisprudence designed to limit the recognition of these rights, to hold back the law from keeping up with the world in which we actually live. This court finds that this is a nonsense argument. By the state's reasoning, the Fetal decision recognizing the right to gay marriage is wrong. Griswold recognizing the right to buy contraception is wrong. Loving versus Virginia recognizing the right to interracial marriage is wrong. Probably Brown versus Board of Education. Now, people who advocate this think you shake their heads and argue, no, we said in Dobbs, we don't mean that. But you can't escape that. You have to lie in order to make that argument and say that that's not what it means, because that's all it means. Just read the dissent in Dobbs. It's unequivocal, it's compelling. I think it's the pinnacle of disingenuity, but it's one embraced by an entire school of thought for purpose of the results they'd like to get rather than principle. To hold that the only unenumerated rights that can be recognized are those that are so deeply rooted in history and tradition that they are already beyond question. Consider for a moment the rights that we take for granted, that were not deeply rooted when these amendments were passed, when these constitutions were written, that would never be cognizable under this doctrine. The rights of women generally, which of course what we're arguing about here, dealing with here today. In 1851, when the Ohio Constitution was written, their rights certainly weren't. They had no legal existence separate from their fathers or their husbands. That right, that general right, that legal existence was not deeply rooted at the time of the Ohio Constitution was written. Then consider, on the other side, the deeply evil values that have at times past been so deeply rooted. Consider that in my own lifetime, homophobia
was widely accepted. And before that, misogyny, segregation, and slavery. Time and progress are inexorable, and the law must move forward, not back, as the state argues. Otherwise, we become what Justice Frankfurt referred to as a stagnant society. We go down the path of Lincoln fear towards despotism. So you see, the Ohio Constitution differs significantly from the federal Constitution. It clearly provides more expansive rights from many different places, certainly in the area of privacy, safety, and healthcare decisions. So for the reasons outlined in the board's TRO decision, those that the board has discussed today, based on the record made here today on the TR, this court has no difficulty holding the Ohio Constitution confers a fundamental right on all Ohioans to privacy, procreation, bodily integrity, and freedom of choice in healthcare decision-making that encompasses the right to abortion. Thus, the state must show that SB 23 is narrowly tailored to achieve a compelling state interest. It has failed to do this. For while the state has some interest in protecting fetal life, that interest must be balanced with the rights of pregnant women in Ohio. As the facts so clearly demonstrate, SB 23 is written in such a way as to almost completely eliminate the rights of Ohio women. It is not narrowly tailored, not even close. In fact, it appears that it might have been designed to be the opposite. That doesn't matter. It's a question of, is it narrowly tailored or not? It's not. To effectively eliminate abortion in Ohio, as it appears it is designed to do, which, as this whole court has already held, holds now, cannot be sustained under Ohio's Constitution. The court will make more extensive findings of fact and conclusions of law. When you look to the parties to submit those, it suffices to say that the court makes a finding of fact. Now, the abortion is safe healthcare, to which Ohio women have a right. The court need not rule what would be permissible under Ohio's Constitution to say that SB 23 is not permissible. The act is unconstitutional. We do not speculate on how a different law will fare because we do not know its terms. So the court directs the parties to submit proposed findings of fact and conclusions of law in the form of a proposed entry for the court's issuance on or before the deadline of October 12, 2022. The court specifically finds now, will reflect its entry because, of course, the court speaks only through its entry. The plaintiffs have demonstrated by clear and convincing evidence that they are likely to succeed on the merits, that they have first and third party standing. They and their patients will suffer irreparable harm. The third parties will suffer no harm. The public interest will be served by this work. So the court will be entered for the marriage. Thank you very much for your patience while the court reviews its findings. We are adjourned. All right.